My name is Brian McGivern. I am an attorney with the Civil Rights Project. I'm here because I've been volunteering with the Workers' Defense Project for a little bit over 2.5 years now. And so, given that exposure, I think I can say with a little bit of authority that rarely are you going to come across a combination of an organization that does such phenomenal work, combined with a client population that is in such dire need of just the kind of help that they provide. And so, really glad that y'all are here today to learn more about the issue of wage theft and kind of the things surrounding it. The first speaker today is going to be Patty Zavala. She's the Workplace Justice Coordinator here. She's been here just about as long as I've been volunteering with the Workers' Defense Project. And so I think I can also say with authority that you're really going to find someone who's more dedicated to helping people. Without further ado, Patty Zavala.
How are y'all doing today? Good. Well, thank y'all so much for coming out here to Workers' Defense Project. This isn't only where our offices are, but this is also our community center. It's called 5604 Manor, so it's pretty easy to find. And this is a community center that's open to all members of the communities, different groups, for a diverse group of people come here and call this their community. My name is Patricia Zavala, as Brian already explained. I work here at Workers' Defense Project, and I'm the Workplace Justice Coordinator. I oversee our Workplace Justice program, which is one of 3 programs. And this program assists thousands of low-wage workers each year to address serious abuses in the workplace. We see a lot of different issues, and there's 3 different ways in which we address some of these serious issues. One is through educating and training workers and small employers in employment issues, educate them about their basic rights, such as minimum wage, overtime, the right to organize. Also, we educate them about their safety rights. Everyone has a right to healthy and safe work site. And also discrimination, retaliation. We see a lot of different types of claims that come up. And our main interest is to ensure that people can increase their potential to find better employment opportunities. Behind me, I just have a few of the pictures to kind of represent some of the things that we do. This is our community center, and different, things that our organization is very active, and we do a lot of different things. But my main focus today is to talk about workplace justice. The other area that we work on is recovering wages for workers who've been denied payment for their work. Workers' Defense Project has recovered nearly $950,000 in back wages for over 1,000 low-wage workers, allowing workers to provide for themselves and their families. And we also ensure access to medical care for workers. We assist workers who are injured on the job to receive medical attention and compensation. 1 out of every 5 construction workers is seriously injured on the job here in Austin. Workplace Justice or Workers' Defense Project is a membership-based organization. We work with low-income workers to ensure dignified treatment in the workplace, and we empower them to advocate for themselves through our innovative education and leadership programs. Our members are the ones that are directly impacted by labor abuses and unfair labor practices. So wage theft. What is wage theft? How is wage theft defined? Anyone know? Y'all know? Yes.
Wage theft. Define it as
Right. So denial for payment of work, and it's not only not being paid at all, but also not being paid minimum wage or not being paid overtime. Each year, Workers Defense Project receives hundreds of cases from low-wage workers in Austin, and we see a variety of different industries such as construction, cleaning, landscaping, childcare, food service, hotels, all of whom have been denied payment for their work. And we work to address this underreported and largely unknown phenomenon. A lot of people don't know that wage theft is an issue or that it even occurs. People say, how can somebody work and just not get paid? How do employers get away with that? Well, unfortunately, they get away with it all the time. And it doesn't only happen here in Austin or in Texas, but it's an epidemic that is happening all across the country. Workers are being systematically being robbed of their wages, and it's especially high occurrence for low-wage workers. 82% of domestic workers do not receive overtime. And 1 out of every 5 construction workers here in Austin are denied payment for their work, which is resulting in 47% of them unable to meet some of their most basic needs. The non-payment of wages affects the quality of life for working families who are faced to force unplanned economic hardships for employers that refuse to pay them. Such as the 12% of Austin construction workers who lost their homes or who were evicted as a result of not being paid. A lot of times people don't have savings to fall back on if they haven't been paid, and so they face eviction, homelessness, not being able to pay for the basic school materials for their children to put food on the table. And so the Workplace Justice Program operates by assisting low-wage workers in negotiating with employers, providing legal representation, and also filing claims with local, state, and federal agencies such as the Texas Workforce Commission, the Department of Labor, the Austin Police Department, as well as small claims courts. We receive cases from low-wage workers at our workers' rights meetings, which happens every Tuesday evening. Workers come here and they're informed about their rights. They go through a workshop. It's about 45 minutes based on a popular education model. And then after that, they're paired with a workers' rights advocate to review their case and assess what the best steps are going to be in order to resolve their case. They get referred to agencies, or they have representatives of Workers Defense Project, attorneys who will negotiate directly with their employer to take legal action to resolve the case. I encourage y'all to come and attend one of our weekly workers' rights meetings. A few of y'all in the room have come to our meetings and come on a regular basis. Are there any questions at this point? Yes. Tuesday evening starting at 7 o'clock. And they are held in Spanish, but we do have interpretation available. Yes, we don't even really ask about people's immigration status because it's irrelevant for us because the laws are applied equally to workers whether or not they have papers or not. So everyone has the right to get paid, doesn't matter what your immigration status is. Any other questions? Okay, so now that I've provided somewhat of a general overview of some of the issues that the vulnerable communities face, I would like to dig a little bit deeper to understand the role that poverty, linguistic and cultural barriers, and varied immigration statuses can play in complicating a worker's ability to stand up for their rights and to be protected under the law. I've worked with hundreds of economically disadvantaged and marginalized workers over the years, and I'd like to share some important considerations and things that I've learned doing this work. But first, I want to recognize something that may be pretty obvious. while I advocate for workers and I stand in solidarity with workers, I'm not a low-wage immigrant worker, and I don't know what it's like to be one, and I probably never will be. I don't know what it's like to work 70 to 80 hours in the hot sun in dangerous working conditions and risking my life to take care of my family and not get paid. So because I haven't experienced this firsthand in my own flesh and blood, I'm not the one who can necessarily speak to that experience, but many of our members have experienced that. And we believe that those who are directly impacted by inequality and have the experiences of injustice are the individuals to lead the movement for change. And so we work to develop leaders here within our organization so that they can be at the forefront and the spokespersons to be able to affect change. And I'd like to introduce one of those leaders today. Her name is Eva Marroquin. She came to Workers Defense Project with a case years ago, and now she's an active member of the organization. She's going to speak for herself and explain what it's like as a low-income worker trying to access the justice system, because there's a lot of barriers to it. And please keep in mind that her experience is just one of the many experiences that our members face on a daily basis. So please assist me in welcoming Eva Marroquin.
Muy buenos días.
Good morning.
Mi nombre es Eva Marroquín.
My name is Eva Marroquin.
Soy miembro y voluntaria del Proyecto de Defensa Laboral.
I'm a member and volunteer of Workers Defense Project.
Llegué a la organización con mi novio
I came to the organization with my boyfriend
con un robo de servicio
with a theft of wages
en el año 2010
in 2010.
y pues vi la necesidad que había de muchas personas que hablaban inglés pero no lo traducían bien al español.
I saw that there was a lot of necessity. They spoke English but didn't translate it very well to Spanish.
Y miraba cómo daban las charlas de derechos laborales.
And I saw that they gave Know Your Rights trainings.
Y como en mi país yo trabajaba en bibliotecas, era entrenadora, capacitadora.
And in my country, I worked in libraries. I was a trainer.
Entonces pregunté si podía ser voluntaria.
So I asked if I could become a volunteer.
Y me dijeron que sí.
They told me yes.
Luego apliqué para ser voluntaria. A los 15 días me hablaron.
Then I applied to become a volunteer, and they called me 15 days.
Empecé a asistir todos los martes.
I started to come every Tuesday.
Entre semana a capacitarme como organizadora voluntaria.
And during the week, I was trained on how to be an organizer and a volunteer.
A capacitarme para poder dar charlas de derechos laborales.
I was trained on how to give Know Your Rights trainings.
Y me fui involucrando en la organización poco a poco.
And I became more and more involved in the organization.
Aprendí a hacer calculaciones sobre las horas de los trabajadores.
I learned how to do calculations for wages for workers.
Y de esta manera me fui involucrando, a la cual ahora tengo 2 años de ser voluntaria.
And that's how I started getting involved, and I have 2 years being a volunteer.
He aprendido a procesar los casos de robo de salario.
I've learned how to process the wage claim cases.
He apoyado a la organización y a las personas.
And I've supported the organization and many people.
Porque realmente el robo de servicio me afectó mucho.
Because the theft of the wages affected me a lot.
Porque mi esposo trabajó y le quedaron debiendo $3,000.
Because my husband worked and ended up owing, he was owed $3,000.
Y la corte decidió que solo pagara $400.
And the court decided that he should only be paid $400.
$500.
$500.
Y realmente él presentó pruebas que no eran y también la corte no lo aceptó.
And there are documents that were presented that the court didn't accept.
Porque presentamos un total al inicio.
Because we presented a total amount at the beginning.
Y al final otro.
And then another.
Pero ellos nunca se dieron cuenta que el investigador privado
But they never realized that the private investigator
dijo que las horas de overtime no se contaban.
said that the overtime hours didn't count.
En realidad esto me afectó bastante porque era la única que mantenía la casa.
In reality, this really affected me a lot because I was the person that supported my household.
Y pues tuvimos problemas con mi novio
And we had problems with my boyfriend
porque él también le había prestado $400,
because I had lent him $400,
dinero de mi bolsa,
money from my own pocket,
para que hiciera un proyecto en una casa.
so that they could do a project in a house.
Por eso se me enciende la sangre cuando los patrones quedan a deber a sus empleados.
That's why my blood boils when employers end up owing money to their workers.
Uno sufre trabajando bajo el sol.
One really suffers working under the sun.
Yo he trabajado en construcción,
I've worked in construction,
mantenimiento,
maintenance,
housekeeper,
and housekeeping,
y realmente también sufrí un accidente en mi trabajo.
and I suffered an accident at work.
Y realmente todavía estoy peleando mi caso.
And even today, I'm still fighting my case.
Y primeramente Dios lo voy a ganar
And hopefully I will win it
porque quiero que la doctora demuestre
because I want the doctor to show
que fue parte del accidente por los líquidos que usaba.
that it was it was related to the workplace because it was from the liquids that I used.
Por este motivo estoy acá,
It's for this reason that I'm here,
apoyando a la gente inmigrante,
supporting immigrant workers,
porque algo que nos afecta es el no hablar inglés.
because something that really affects us is not being able to speak English.
Cuando van a las cortes,
When we go to court,
muchas veces los abogados o los representantes no traducen lo que realmente el hispano quiere.
a lot of times the courts don't actually translate what we're trying to say.
Y realmente es una de las grandes cosas que afecta al hispano.
And it really is one of the biggest things that affects Hispanics.
Muchas veces le dicen firma aquí
And a lot of times they say, just sign here.
y como uno no sabe,
And since a person doesn't know,
está afirmando que es culpable uno.
they're signing that they're guilty of something.
Y es una parte que nos ha afectado como los hispanos, cómo sufren el robo de salario, cómo afecta a las familias realmente.
And this is something that really affects families.
Y por eso es que estoy aquí ayudando todos los martes con las calculaciones,
And that's why I'm here helping in every way, helping calculate wages that are owed,
ayudando a hacer las aplicaciones para que puedan aplicar en los recintos para que les paguen,
helping people fill out applications so that they are paid.
porque realmente en los recintos muchas veces no hablan español.
Because in a lot of the precincts, they don't speak Spanish.
Y a mí me pasó cuando fui a aplicar para que me paguen los 400 que el patrón le quedó debiendo a mi novio.
And it happened to me when I went to the court to recover the wages. They didn't speak Spanish.
Me discriminaron
They discriminated against me
simplemente por verme el rostro de hispana.
just simply to see my Hispanic
Y
face.
creo que esto no es justo.
And I don't think this is fair.
Para Dios todos somos iguales.
Under God, we're all the same.
Dios bendice a todos por igual y a nadie por indiferente.
God creates us all equal, and nobody's different.
Y gracias por estar aquí. Espero pasen un buen día.
And thank you for being here, and I hope you have a good day. Do you have any questions? Okay, thank you. So Eva brought up some important points that it's important for us to keep in mind as we're working on these cases and our clients. I'm not an attorney. I'm an organizer. I work with workers so that they can defend their rights in the workplace. And I'm also an advocate, and I advocate for workers on their behalf so that they seek just compensation. However, I do have studied the law, and I know a lot about it. And through my experiences, I've learned a lot of things, just hands-on practical things. One thing that's really important to keep in mind is that many workers are intimidated by the process of recovering their wages and working with attorneys. Many workers have never worked with an attorney before, and especially an attorney who doesn't speak their language. It's important to be aware of linguistic differences and ensure that you have a skilled professional interpreter at all times to ensure language equality and avoid miscommunications. Do any of y'all speak Spanish in the room? Okay, wow. So almost everybody. So that's great. It's a really great skill to be able to communicate with your clients. One of the most important things, of course. But a lot of I've seen a lot of cases where we go to court and they don't provide an interpreter. Their interpreter doesn't have the skill level, and it ends up affecting the case. So investing in interpretation and translation is something that's really important to have a good relationship with your clients. Also, understanding that the bureaucracy of government agencies and courts can be very complicated, complex, and intimidating to workers. It takes a lot of experience to really understand how these processes work. So keep it simple and when you're explaining the case to your client, and you don't want them to give up or feel hopeless or feel isolated or marginalized from their case. It's important to put yourself in their shoes. Imagine you're in a foreign country in Indonesia and you're trying to understand how their government systems work, and nobody can understand you, what you're saying, and you can't understand them. You really have to try to imagine what it would be like to be somebody here who suffered an injustice and is trying to defend their rights and the barriers that would present themselves. Also, a really big, serious concern is that workers are oftentimes in a pinch for money because of the logistics of being economically disadvantaged. Many low-income workers, like I said before, don't have savings. So when they don't get paid, they have nothing to fall back on and are put into situations of extreme economic hardship. So they're not going to have any money to pay any upfront costs. And every trip they make to your office or to court is money that they're spending on gas and time that they're spending that they just simply don't have. So they're making big sacrifices just to pursue their case. And we recognize that it takes a lot of courage to stand up for your rights, to come here to Workers' Defense Project. People are under constant threat and fear of retaliation from their employer and losing their jobs. And so it's important for us to really recognize that people are making a really big, important decision by even taking the initial steps to pursue their case and come to you. So it's important to put really high priority on these cases, especially when we see that people are actively involved or really interested in their case or really take the appropriate proactive steps to pursue a case. So return their calls immediately, put their case at high priority. So often, low-wage workers are mistreated and disrespected, ignored in society and by other people, and so we need to treat them with overwhelming respect and equality. This can be one of the only places where people can come and feel that they're treated equally in society. So a lot of times people are in a desperate situation, and because of their economic disadvantage, and will oftentimes settle for a lot less than what they're actually owed, and they'll settle sooner rather than later just to get something, some of their money rather than nothing. And as attorneys and advocates, we want to push them to fight for what's rightfully theirs, what they honestly earned. But we also want to be careful not to push them too much because we want to recognize the situation that they're in. It's easy for a person of privilege to say, no, don't accept that settlement, keep fighting, stand up, fight for every single cent that you're owed. But we also want to recognize that people need to put food on the table. So oftentimes being in need of money and in a desperate situation, workers will go wherever the job is. So if you have to go to Oklahoma or Florida, they're gonna go. So a lot of times our clientele is very transient. So it's important to make sure that you get alternative emergency contact phone numbers. So we always ask, do you have the phone number of a loved one that you stay in contact with? What's your phone number in your home country? And we also get the address in their home country because it's happened very often where we get a settlement check, and then we can't get in touch with them. And sometimes the best place to go is to check is their home in their home country. So be patient, because a lot of times people's phone numbers get disconnected. Cricket is a phone service that you can just it's a contract that you can pick up and end really easily, and so Cricket phone numbers end up getting disconnected really easily, and so it can be really challenging to get in touch with people. But be patient, because they will eventually show up and get back in contact with you. Another consideration is that workers may be morally outraged that they've been wronged, and that could be a good thing. So when a lot of times for us, they've come and they say, it's not just that I want my wages back or that I necessarily want to win my case, but I just don't want this to continue to happen to other people. And they care more about the bigger picture. And so this could potentially be a very strategic case that could be evaluated for impact litigation, and you could make change with those types of case. And these types of clients that are committed to the bigger picture could create opportunities to collaborate with other organizations to push forward for policy changes. So Workers Defense Project takes cases so that we can create changes in policy. For example, a group of workers worked on a high-rise apartment complex in West Campus, and 3 of them fell 13 stories to their death, and there were 40 workers that were left behind not being paid minimum wage or overtime. And they came forward, and we worked on the case, started to do a class action lawsuit, and through that case, we were able to highlight the abuses that are going on in the industry and be able to make clear demands on our city council to pass an ordinance to ensure better protections for workers. And through that, we were able to get Austin's first rest break ordinance that provides workers a rest break for 10 minutes every 4 hours. So that's if you're interested in making some sort of change through your legal work, then those clients who are really interested and committed to their case will open doors to be able to collaborate with organizations like ours or other policy organizations. Also, many workers are going to be concerned about their immigration status. There's a federal policy that I'm sure many of you know about that creates a collaboration between local law enforcement and immigration enforcement. Tens of thousands of non-criminal immigrants have been deported through this program called Secure Communities. So the trust between immigrant community and the police has deteriorated since this program took effect. So workers are scared to confront their bosses, they're scared to go to court, report theft of wages to the police, because they've seen their families and their communities torn apart by coming into contact with law enforcement. So we need to be aware of the political anti-immigrant climate, and in this context, be very considerate of what it is that you ask of your client. Some people think that testifying in court can get them in trouble, and sometimes it's possible that they could come into contact with law enforcement in the court. So we need to allay their concerns, but also be very honest with them about any risk, and inform ourselves about any risk associated with pursuing their wage claim. Another consideration is to recognize that anytime a client or a worker is coming to a hearing or to a meeting, it's very likely that they're missing work, which can be a really big hit for workers. Low-wage workers are mostly hourly employees, or they're independent contractors, so they're not salaried. So if they don't work, they don't get paid. So missing a day of work to go to a hearing or attend a meeting with you can mean not earning maybe $200 that would otherwise go to pay rent. So they're making really big sacrifices, and if they ask for a few hours off of work, maybe for a hearing, it's common that the employer will tell them to not come in for the entire day. And if they miss too much work, then they will they could potentially lose their jobs. Many employers see low-wage workers as disposable. So always make sure to set your meetings with them in the evenings and on the weekends when they are available. Make yourself available for them and not the other way around. To wrap up, I'd like to share a video with you that summarizes a little bit about what we've talked about, and this highlights a tragic story of one of our members and also explains the vision of Workers Defense Project and how we seek to create a more just and fair Austin and build a better Texas. So if somebody could hit the lights, please.
Bájense corriendo, güeyes, y la chingada. Órale, putos pendejos. Pues nos trataban mal también los coyotes. Y ahí vamos bajándonos, todos nos bajamos y brincamos una cerca de púas, de alambre de púas, y brincamos para aquel lado. Y órale, que nos van a ver y nos van a agarrar. Y ya, total, nos bajamos todos y al monte, correr como una milla para clavarse en donde está más grande el monte. Y ya así quedó ya se fueron las camionetas y dijo el coyote, pues ya, dijo, pensamos que nos íbamos a ir en camioneta, pero ahora vamos a caminar, dijo, todas son como 2 días o 3 caminando. Hijo de su, no, pues ya vamos a caminar y pues ya empezamos a caminar, que serían como las 8:30, pero a las 8:30 ya estaba el solezote bien alto, ya estaba caliente. Y no, pues órale, a agarrar agua de donde toman las vacas y ahí de soplo para que se hagan los animalitos para los lados y llenas el garrafón de agua ahí. Y la muchacha, pues ella le dijo, sí, vas bien, sí, la muchacha, sí, muy bien, bien alegre y todo, sí, muy bien, muy bien. No, pero ya cuando nos paramos en ese montecito como a las 3:30, ya no quiso comer. Le dije al coyote, le dije, oye, espérate, le dije, esta muchacha no va bien. Ah, dijo, sí, va bien. Y sí, caminó, pero nomás dio como 2 pasos y a los 2 pasos ya se desmayó. Ya me hinqué en el suelo, me hinqué y me la puse aquí. Y no quería despertar. Y ya duramos como 40 minutos, yo creo, casi una hora ahí con ella. Yo con ella aquí, yo la tenía aquí, yo echándole agua y hablándole. Tenemos que llegar, le digo, no te puedes quedar aquí. Y no, la muchacha pues no, nomás hacía, nomás hacía así, pero no podía, no hablaba nada. Y ya me acuerdo que al último yo creo que ella ya sabía que se iba a morir, porque al último empezó a llorar. Me acuerdo que cuando yo la tenía aquí, se le empezaron a salir las lágrimas. Y le dice, no, maestro, ya se murió. No, ¿cómo no chingues? ¿Cómo se va a morir? Si ya se murió, ya no podemos hacer nada.
Workers Defense Project is a community, and it's a community with a vision for a better city, an Austin that respects and includes us, a just city. We are a community center made by and for our worker members. The entire building was fully remodeled, totally by volunteer work, by our community.
Immigrant workers come into the organization, they're not always aware that they have a lot of the same rights as people that have documentation do. For example, the right to a safe and healthy workplace, the right to get back wages if they did a job. And so one of the things that we offer are free safety trainings to workers. The safety training itself, it's very interactive, participatory. They're as large as 40 people per training, but they work in small groups. So it's each one, teach one. That's a key model that we use. The training cultivates leadership skills as part of the training itself, not just communication of technical safety training knowledge. And the great thing about our safety training, specifically OSHA 10 trainings, it's a 10-hour course in the construction industry, is it's built around organizing. It teaches workers about their rights, but not just about that, but how to fight for their rights, how to organize for their rights. And that's a really important component to worker empowerment, and that's what our organization is about.
Our members are the working people of Austin, the people who build, maintain, and take care of Austin, the people that feed Austin, those who have built our streets, our bridges, our homes, our schools, those who care for our sick, our elderly, and our children. Here at Workers' Defense Project, people come to play, to meet, to dance. They come for help, and they come to give help in return. They come to learn, but then in the classroom we realize that we are all teachers ourselves. And ultimately, we unite here to fight for the changes that our community needs to survive. We are going to build a better Austin for everyone.
Como trabajadora sufrí una lesión en el ojo que no me fue recompensado y estoy luchando en eso. Y es muy difícil uno como inmigrante en este país porque no tiene los derechos que los ciudadanos americanos lo tienen. Y yo me siento feliz de ser parte de la organización, es mi familia, es un orgullo formar parte de ellos y también a la vez invitar a mucha gente que quiera ser voluntaria del proyecto de defensa laboral. Yo le digo a todo trabajador, inmigrante o no inmigrante, americano y no americano, que sepan muy bien que no están solos, que cuentan con el proyecto de defensa laboral que es su familia y que damos apoyo cuando más lo necesiten.
We were all immigrants once. Why do we continue to stand divided? Why do we continue to ignore our fellow brothers and sisters because of the way they look, the language they speak, the creed they follow, whom they choose to love? Why do we allow ourselves to be told that our neighbors are not our brothers and sisters, but indeed our enemies? These workers are the greatest philanthropists, and these workers have voices. And here their voices are becoming united. They ask one more question. Will you stand with us?
So will you stand with us? Will you stand for the rights of workers with Workers' Defense Project? Yes or no? Okay.
Okay, getting started again. You're about to hear a presentation from David Van Oss, and really an introduction that would do him credit would probably be a presentation in itself. Suffice it to say, Mr. Van Oss has been just a remarkable attorney for civil rights and workers' rights and everything else like that under the sun for decades, and I really have the utmost respect for him, and we're really privileged to have him here today. So, without further ado.
Thank you. The privilege is mine to be here, and I really want to give a shout out and a commendation and way to go, guys, to Workers' Defense Project for putting this program on and for everything they've been doing in the community to increase empowerment and self-empowerment and knowledge and tools for justice for workers. They've been doing a great job, and I just want to thank the Workers' Defense Project for take this opportunity to thank the Workers' Defense Project for everything that they do. The case study, as I'll call it in quotes, that I'm going to present to you is a story, a real life story about courage, about incredible dedication to fundamental principles at the cost of personal sacrifice. It's a story about public servants uniting to stand together for fundamental principles. It's about the power of worker solidarity. It's about the power of truth. It's about the power of fighting back against corruption and unfairness and injustice. And it is also about the use of legal action in a supporting role as a critical piece of the pie. Now, in my view, no lawsuit ever organized a factory. And when lawyers are using the skills of their trade to support collective worker action, the lawyers always need to view themselves as a support role. And the lawyers always need to understand and to keep telling themselves that the most important piece of the struggle is the worker action, the collective action, the solidarity. And that the job of the lawyers is to support that and to use the training and the skills of our particular trade to be good support and to be effective in how we provide that support. I've given you some handouts, and I apologize in advance if there's not quite enough to go around, because when I was out of town yesterday, my office employees were photocopying the handouts. The copying machine broke down. And so we didn't make as many as I intended to make, but doing a head count, I think maybe that all of you have one. And this story is illustrated graphically with the printed material here. The handout begins with a news story in a blog that is pretty well known, that some of you might be familiar with, called Grits for Breakfast, which is a blog that regularly and continually comments on criminal justice issues in really pretty much all over Texas. They comment about events in Houston, San Antonio, Dallas, and it's pretty widely read among people in or related to the criminal justice field. And this first news story, dated January the 3rd, 2007, is about a rally and a press conference that was held by a large number of probation officers in the adult probation office in Bexar County in January of 2007. At this point in time, there were no lawyers involved. There was no legal actions. And what this, as the story calls it, they were staging a protest. What had happened was that over 200 of the probation officers in the Bexar County San Antonio probation office had signed a petition saying that in support of a written grievance that they filed as a huge group with the director of the probation office, complaining about working conditions. And in this grievance, they designated the Service Employees International Union, SEIU, as their representative. Under Texas law, public employees have an absolute right, and that's actually what the court cases have called it, an absolute right to present grievances over wages, hours, or working conditions through a representative, which can be a union. And so this dissatisfaction had been mounting up, and it really started when the director of the probation office, who was newly installed in that job, had moved to Texas from Arizona to take this job, and unfortunately had some Arizona mentality that he brought with him, if you follow anything about the politics of Arizona. And what he had done that really caught the attention of his probation, of his workforce, is that he, in a new budget, had gotten a whopping big pay raise for himself, while with no pay raises for the rank and file workforce. And one of the things about probation officers in Texas is they are very badly underpaid. And it's gotten worse over the past 8 to 10 years with the budget cutting, stingy budget cutting mentality that's been dominating the Texas legislature. Probation officers are terribly underpaid. They're like teachers. And so when these probation officers read about and heard about, and the budget hearings are public meetings, and a lot of them always attend every year because they want to know if they're going to finally get some relief. When they read about and heard about and saw their boss just brazenly getting a big raise for himself without even recommending any across-the-board raises, even cost of living increases for the workforce, well, they went ballistic. And they got together as a group, circulated a petition under this written grievance, complaining about a lot of working conditions. For example, there was one of the suites of their offices had rats running around in it, and they couldn't get the boss to do anything about it, or the county commissioners to do anything about it. Probation officers in Texas, in adult probation officers, are actually employees of the state of Texas, not of the counties. But there's the legislation in the government code has this weird hybrid that probation officers are employees of the state, and an adult probation office, which legally is called a community supervision and corrections department, is actually a political subdivision and an arm of the state of Texas. But under the legislation, the county commissioners court of each of the county has some say in the working conditions, and they provide the physical facilities. Each probation department is actually, their governing board is actually all of the criminal district judges of the county and all criminal county court at law judges. They're like the governing board, and they do the hiring and firing of the director of each probation office. Well, this big protest that the probation officers staged got a lot of press attention. And what had led to the protest was that when they submitted their big grievance petition, the probation director, the boss, a man named William Fitzgerald, at first said, okay, I'll meet with you, because they designated 3 representatives of their group to meet with him. He first said, I'll meet with you. And then a couple of days later, he sends them this very snarling email that says, no, I've decided I'm not going to meet with any union. And 2 days later, and this was right before Christmas in 2006, 2 days later, he issues a mass email to the whole workforce that says, you're all going to be laid off effective the end of January. And if you want to reapply for your job, you need to submit an application by January something or another, and then you will have a retention interview to decide if you're going to be rehired for their job. This was open, mass, flagrant retaliation, because over 200 of them, which was about half the whole department, had signed the grievance petition. So then they have this protest rally. It draws press coverage, and this is something about the power of collective action by workers, because the bigger the numbers, the higher the potential is for press coverage. And press coverage is power. So, because people in the public read it and they start talking about it. Then after they had their protest rally, in their rally they demanded that he withdraw the requirement that they reapply for their jobs and cancel the retention interviews. Then they decided, well, maybe they should seek legal advice, because they figured that this retaliation had violated their constitutional rights. They ended up coming to me. I discussed it with them, and what they did was they formed their own union, their own worker organization, because the SEIU, for reasons that I won't criticize, the SEIU had other organizing priorities that they were already in the middle of, and the SEIU at that point in time decided that it just didn't have the resources or the staff power to also take on this fight. So then they formed their own worker organization, and they came to me as an organization, and I agreed to represent them. And this is another lesson that we lawyers sometimes have to learn, and that is we cannot really fulfill our duty to justice by being bean counters all the time. And I took this on. They agreed in a written contract to, as a group, make some modest monthly payments for my time and especially expenses. I knew they probably wouldn't be able to keep that up and fulfill it. I really didn't know how I was going to handle the cost of this lawsuit, but I did it. I just had to do it because it was such a crying need. They had been to some other lawyers, and the lawyers that they went to first all turned them down because they would literally be suing all the district judges, and the lawyers didn't want to do that. Well, I don't have a criminal law practice, and so I wasn't in a position where I had to worry about what criminal district judges thought about me or what they might think about my clients, so I agreed to take this on. The very last thing in the handout is a sample contract for legal services that is a three-way contract, a three-party contract. And this is a model of contracts I've actually used, but the names of the parties are fictitious. If an organization such as a labor organization is going to engage your services as a lawyer to represent members of the organization, you need a contract that is signed as a three-way contract between yourself, the individual client, and the organization. And there are real specific ethical reasons that you need this. In the Texas Code of Professional Ethics that we that govern our conduct as lawyers. The code says that a lawyer can be paid by a third-party organization to represent a client. Insurance defense lawyers, this is their practice, basically. But that the lawyer cannot allow the organization to interfere with the lawyer's independent judgment on behalf of the individual client. And the purpose of this three-way contract is to make it clear to everybody, and everybody understands, one, the client agrees to have the client agrees to the third-party organization paying his lawyer. It makes it clear that the third-party organization is providing it. It says the third-party organization is that the arrangements for legal fees and reimbursement for costs are a matter between the third-party organization and the lawyer, that the lawyer recognizes that his independent judgment has to be exclusively on behalf of the individual client, and the organization agrees to, in writing this contract, that it recognizes that. And where you're representing a group of people in a consolidated legal case, under the conflict rules of the ethical code, you need something where each individual client consents to the co-representation and recognizes that the co-representation might require you sharing each client's confidential information with the other clients for the purposes of facilitating, and that's all spelled out in this model contract. This is one that I use, and just with fictitious names as a model. So what I did then was I filed this lawsuit, and there's always safety in numbers, and the handout has a copy of this plaintiff's original petition. It lists all the individuals as clients. They all agreed to do it together because of the safety in numbers. And one thing that I urge you, commend to you as lawyers, when you are drafting a lawsuit in which you know there is public interest or will be public interest, and you know that your clients have a strong interest in public relations and in favorable facility, in your pleading, you spell out the facts in detail with the knowledge that you are talking to the public. Because it is a public document. And even though you're directing it to the court, in fact, you are speaking in public because it is a public document. Now, this is a sample of spelling out the facts in meticulous, excruciating detail. And when you do it, you got to take a lot of time interviewing your clients and reviewing their documents, because when you spell out the facts, you're going out on a limb in the public domain, and you got to get them right. They got to be accurate. You can't fudge when you're using a pleading in this context and for this purpose. And this pleading is a model, and it is the pleading that started the legal action, which was one supporting front in this struggle. I filed it in state court, pleading a lot of federal causes of action. I figured they'd probably remove it to federal court, and that was fine with me. But I filed it in state court so that the other side would at least have the option. And then the next thing, I filed the lawsuit in March, and less than 2 months later, the probation director canceled the retention interviews and withdrew all those directives about you're all going to be laid off and you have to reapply for your jobs. Clearly because of the lawsuit. And when you as lawyers are dealing with something on which there's a lot of public interest, in which there's a lot of public light shining on what's going on, not all lawyers agree with this, but it's something that I am 100% stand behind. And that is, you got to talk to the press, because you're taking a lead role in something that is in the public eye, and the press wants to talk to you. You got to talk to them, because it's in your client's interest. Because it's in your client's interest to for the public to know what's going on. And journalists like to talk to people who will talk to them. And if the journalists realize that you will be open with them and you will talk to them, then they'll start calling you regularly. And in your client's interest, your client's story is getting printed in the public eye. And my advice to you is, when you talk to the press, don't be cagey with them. Don't play poker with them. Be blunt. Be plain spoken. Say what you think. And so, when the news came out about Fitzgerald withdrawing the retention officers, well, the San Antonio Express news reporter who was covering the story and who knew about it because of the public protest actions and rallies the probation officer has held, called me on the phone. And I was just really blunt and plain spoken. And she quoted me with 100% accuracy. I said they're being called off because my client sued him. What he did was flagrantly retaliatory. But I said that this doesn't make my client's lawsuit go away, because my clients still need to be heard on their grievance petition, as to which he still never met with them, and they still have a lot of problems, and they're still suing for money damages. So after this was in the newspaper, the next day, the Assistant Attorney General handling the case sent me a letter. And in this letter, he said, letter dated May 18th, 2007, under Greg Abbott's letterhead, he said to me, quote, "Congratulations on the public," no, he said, I also understand that you have held a press conference today to discuss your client's claims. Congratulations on the publicity you are managing to generate for your law practice. Well, I didn't appreciate that. I thought that was incredibly inappropriate for a lawyer to say, who was a public servant and who was representing the public in defending against the lawsuit. So I wrote him back and I demanded an apology. And he refused to give me an apology, so I wrote his boss. There's nothing classified about these letters, because it's litigation that's over with and closed, and so this is all available through open records. Nothing confidential about him anyway. I wrote his boss. So you got in this handout a copy of a letter dated May 22nd, 2007, addressed to Robert O'Keefe, who was chief of the General Litigation Division. And this is in the handout. You can read the whole letter, in which I demand an apology. And you might want to check out the last sentence. And the reason I bring this up to you is because when you, as a lawyer, are handling a legal case that is strongly in the public eye, and in which you have a group of workers who are depending on you to represent them, and who are in a fight for their survival as workers and who are fighting to be given the respect of making their boss acknowledge and recognize that they are a group. And they want to be dealt with as a union, as a group, and he's refusing to do it. Well, what you got to do, and this is incumbent on you, is you got to be tough on behalf of those clients, because they didn't retain you to be a milquetoast. They retained you because they wanted a fighter, because they're in a fight. So it is in my client's interest that I had to let the Attorney General's office know that they are in for a fight, and this kind of bullshit is not going to be tolerated. So take a look at the last sentence, the last paragraph of this letter. Ironically, Attorney General Abbott and your agency's publicity department have no qualms about sending out press releases or holding press conferences concerning litigation. One can find numerous examples at your agency's website, which was the truth. And I never got the specific apology, but I do know that Mr. Henneke was replaced by a different assistant attorney general about 2 months later. That's all I know. And there's more in here about how you have to represent, when you are representing workers organized and united who are fighting for recognition and for respect as a united group. You have to always keep that in mind. And so one of the things that the Assistant AG Henneke said in his letter, in his letter to me, is that, you know, a couple of your clients came to Mr. Fitzgerald and tried to talk to him about some of their issues. And he says to me, I don't think they should do that. I think it would be better if all the communications about your clients' issues were channeled through us as the lawyers. And I said back to him, well, no, the May 25th letter is something different that you can read. In the interest of time I'm going to blow past it. The May 30th letter from Henneke to me is when he asks that the communications pertaining to union activities and your clients' issues be channeled through the lawyers. And I had to say back to him in my letter of June the 11th, because when you're representing workers organized as a group who want to be organized and act as a group, you always got to keep in mind what the real issues are for your clients. So I said back to him, to ask my clients and their fellow employees to withhold the exercise of protected rights in order to wait on an extra layer of communications between lawyers would simply compound the chilling effects my clients have already suffered. And so, no, my clients and their employees are peaceably organizing a union. They feel the need for support as a union organization. My clients filed a lawsuit to seek judicial protection for their activities, and it would be a perverse result if their pursuit of redress were to result in greater limitations on their collective action. So no, we're not going to go through lawyers when my clients want to discuss their grievances and their working conditions with the boss. I ended up having to take depositions of some district judges. There's a sample here of a letter to one of the district judges telling him I need to take his deposition. District judges, in civil matters, district judges are represented by the Attorney General, because district judges are arms of the state. There's some more paper trail in here about the basically rather confrontational relationship that I had with the Attorney General's office in handling this. That's not necessarily fun, but when your clients are in a fight, you got to be a fighter. And you cannot worry about being diplomatic, and you cannot worry about anybody on the adversary side thinking ill of you for being tough. Then July 8th, there's a July 8th, 2008, another newspaper story. In May of 2008, a woman named Sherry Simonelli, who was the president of the probation officers organization and really the toughest lead person and the person who really demonstrated incredible courage. The probation office had contracted out all of its urinalysis testing of probationers to a vendor. The vendor was atrocious, and immediately the vendor's testing resulted in a mass barrage of false positives. And the probation officers who were familiar with their probationers that they were supervising, when they started getting these reports from the drug testing laboratory that reports of testing positive for methamphetamines and heroin and cocaine, all the hard drugs for probationers that the probation officers knew were not hard drug users. Well, the probation officers got upset. And the probation officers became concerned as a group that probationers were going to jail on motions to revoke arrest warrants who were clean, because they had probationers in their offices crying to them and bawling and breaking down, and I don't do this. What is this happening? Why is this happening to me? And there were some pretty outrageous stories of probationers, like a woman who spent the last 6 weeks of her pregnancy in jail for a false positive drug test result. And so the president of the Probation Officers Union, Sherry Simonelli, sent an email to all the members of her union from her home computer on a Saturday night, totally away from work time or from work or from state facilities or resources, in which she told them, I think you should stop sending probationers for drug tests, because the drug testing laboratory, we all know it's issuing false positives, and therefore we are being involved in violating citizens' constitutional rights by when we send them for drug tests. Well, if Sherry had consulted with me before she wrote that email, I probably would have advised her to be a little more careful about the way she put it. She was fired for insubordination. Mass rallies were held. The entire labor community in San Antonio took up the banner for her. The July 28th, 2008 Express News story is about a giant labor rally attended by people from a lot of unions in San Antonio in support of Sherry. Sherry's really tough. I went with her to an internal agency grievance hearing, and she said to her boss, if I had to do it over again, I would do exactly the same thing again. What I did was right. You know that drug testing laboratory is causing people to be put in jail wrongly. What I did was right, and what you need to do is cancel the contract instead of disciplining me. Well, he fired her, as she knew that he would. We ended up filing suit. By this point in time, the probation officers union had affiliated with the United Steelworkers of America, and they are actually a steelworkers local today. Well, the United Steel, and this brought in the resources of a major international union. And the United Steelworkers International did not take kindly to their local union president being fired for doing something that was right as a matter of conscience. So that initiated another round of litigation. The plaintiff's first amended complaint in that lawsuit is in the handout. After the handout about the July rally at the Bexar County Courthouse, And Sherry, I wish she was here. She was going to be here to co-present this with me, and she is sick in bed this morning with the flu. She's an amazing individual. Being fired from her job put a really bad crimp in she and her husband's household income, but she stuck to her guns and what happened was we consolidated the first lawsuit, which was still pending, with the lawsuit over her firing, made it a union issue. There's pleadings in that plaintiff's first amended petition about how to plead the standing of an organization. And so that pleading is in there. And another reason that I advocate being very detailed factually in your pleading is that is a surefire way to not have to face a motion to dismiss under this recent Twombly ruling from the Supreme Court. And so these cases didn't face motions to dismiss over not being factually sufficient to lay out claims for relief. And I can tell you that it took 2 years to settle these lawsuits ultimately. The terms of the settlements are confidential, but it's a matter of public record that Sherry Simonelli ended up going back to work. And she is the president of the union today, and now their membership is well over half of the department, and they have a very good partnership relationship with the new management. This handout includes more if you're interested in reading it, because I think it is a real important story about public corruption and about workers united putting an end to the public corruption. One of the objectives of the campaign was to get the criminal judges to fire the probation director, William Fitzgerald. And with all the publicity, and there's good long stories from the San Antonio Current, which is kind of like the Austin Chronicle. There's good long stories in here about the drug testing scandal, about the anti-union scandals, because in depositions in the lawsuits, a lot of stuff came out about the anti-union motivations. A witness stepped forward who said that she was at a Christmas party at Bill Fitzgerald's house, and Bill Fitzgerald told her, "I'm going to get rid of all those people that led that petition." And it was about a day later that he came out with the directive that everybody has to reapply for their jobs. When the AG took Sherry's deposition, she stuck by her guns. She said what I did was right. And then she said in her deposition, yeah, it's hurting me and my husband's household income badly, but I don't regret it. I would do it again. And if me losing my job is the price that has to be paid for bringing justice to that drug testing situation, then I'm willing to pay the price. I mean, just incredibly courageous woman. And with that kind of courage being demonstrated by their president, these probation officers stuck with her and stuck together. They kept coming to all the rallies. There were some really dark times. I mean, it took 2 years to finally settle the lawsuits. There were some really dark times. There were some times when some of my probation officer clients and some of the union members got really discouraged. I mean, they felt like, maybe Fitzgerald really won because he got rid of Sherry. And, now nobody wants to join the union anymore because they saw what happened to our president. And there were some dark times when they were discouraged because it's a long fight. And the power of worker organization, people being together, is that people work with each other to keep their morale up through the dark times. And people work with each other to encourage each other to be patient and to keep the faith. Now, what eventually happened to Bill Fitzgerald is that finally, in no small part because of the drug testing scandal, and in no small part because the workforce was so unhappy with him, and this is where the public eye made such a difference. It impressed the conservative editorial board of the San Antonio Express-News. It impressed them greatly that a large group of these probation officers were so insistent about being treated unjustly and about the probation office being run in a bad way. It impressed them that these people were so willing to keep stepping out in public. And eventually, the Express-News wrote an editorial calling on Fitzgerald to resign. 4 days later, he announced that he was going to resign. Then the judges had to pick a new probation director. They held a meeting. There was one manager that the union and the rank and file probation officers wanted to get the job. A gentleman by the name of Jarvis Anderson. He was Sherry's immediate supervisor, and he had been very supportive of her, granting her all of her requests for vacation time to go handle union business, to go to rallies. He was a really good guy. Now, he's a tough manager, and sometimes he criticized Sherry when he needed to do so. And sometimes he faulted Sherry, sometimes he reprimanded her, and she's okay with that. That's fine. All a worker really has a right to expect, and most workers really want and expect simply to be treated fairly, to be treated with open minds. And so the probation officers wanted Jarvis Anderson to be the new director. They liked him a lot. They wanted the judges to hire from within. But the district judges went through a big process of interviewing, and then they met in a courtroom. When it came time to conduct their vote as a whole group on which applicant to hire, they told the public to leave the courtroom, and they closed the courtroom door and conducted their vote in secret. They violated the Open Meetings Act. And so we held press conferences about it. We said they violated the Open Meetings Act. It was obvious. Now, newspapers are pretty sensitive about open meetings laws, right? So the Express-News editorialized that the judges had violated the Open Meetings Act and needed to redo their vote. The judges decided to redo their vote. The real reason I think that they wanted to close the doors is because they didn't want the probation officers and their union leaders to see what they did. And so the judges agreed to redo their vote. We all went to this big meeting, and when they were considering redoing their vote, they took public comments, and we all told them that what they had done was a disgrace because they were judges and they shouldn't be violating well-known laws. And so they redid their vote, and when they had to do it in the open, in front of all the affected workers, the probation officers, they completely changed their vote, and they voted to appoint Jarvis Anderson, the one that the probation officers wanted. And he's the director today. And he has a very good working relationship with the rank and file officers and with the union. And throughout all of this, even while this stuff was going on, there were all the lawsuits still pending, still being fought out. The fact that Fitzgerald's actions had caused so many lawsuits to be filed against the department was one of the considerations and one of the factors that generated the public outcry that he needed to go. And eventually, the lawsuits were settled. And like I say, Sherry's back at work, and it's a matter of public record that after the settlement, the probation office, because Jarvis Anderson was director by the time we settled, so he was the client of the Attorney General. And after the settlement, management at the probation office posted a memorandum to employees on their on the bulletin boards about employees' rights to join a union if they wish to do so. So I hope that all of this is of some value to you. I know it's not specifically about wage theft, but I think it's transportable to any worker situation. When you have a group of workers, first thing, my first piece of advice is get them to create a union. You don't have to have collective bargaining rights to be a union. You can call it an association. You can call it whatever you want. But if they are organized and have an organizational identity that gives them a greater identity immediately in the eyes of the public, and if they have an organizational identity, then they have the safety of numbers. Then they have a collective organized voice. The influence, the effect of a collective of workers having a collective organized voice, in some ways it's almost mystical, but it's real. It is very, very real. And when they need legal action and they come to you as to use your legal training and the skills of your trade to help them as legal action, view it as a privilege. Help them if you can. And when you help them, don't be afraid. Don't be afraid to be quoted in public. Be blunt and plain spoken if a newspaper talks to you. And always, always keep in mind that the real goal of everything is the worker empowerment, the worker's ability to have a better workplace, to have more dignity and respect in their jobs, which is where they spend over half of their waking hours throughout their lives, and use that your job is to support them and to be there for them and to fashion and construct your legal work in such a way that, bottom line, it always supports the workers' collective organization and collective empowerment. I've pretty much used up my time, but I think I can take maybe 2 or 3 questions if there are any. Questions or comments or criticism or rotten tomatoes, whatever. Yes.
I know you ran for Attorney General.
Yes.
Was that before or after this?
Before.
That was before.
Yes.
Do you think that had any role in the bad attitude?
Oh, from the AG?
Yeah.
I thought about that. I considered that possibility, and I do consider it as a possibility.
Former assistant.
Okay.
And I mean, sometimes it's hard to say how much that stuff trickles down.
Yeah.
To the AAG levels. But
There's nothing concrete that I could point to. I did find it ironic that a servant of Greg Abbott was criticizing me for publicity, for seeking publicity. He is the biggest publicity hound in public office anywhere in the state of Texas, and you all should know that. Anything else? Well, thank you all very much for your attention. I hope I didn't put you to sleep.
So, as you can see from your agenda, the next part of the seminar today is a presentation by Edmund Moreland, who has been kind enough to come out and give us what's going to be a great presentation on wage and hour claims in their various respects and all the factors you should take into account when working on one. So, Edmund Moreland.
Thanks very much, Brian. First of all, I want to thank the organizers of this seminar for putting it on. I'm sure I missed the first presentation, but I'm sure you all have heard the number 19 billion, which is what I understand to be a conservative estimate as to the amount of money lost to workers every year through wage theft. 19 billion. I must have had somebody draw the short straw for me to follow a luminary like David Van Oss, but I am going to sort of complement David's macro approach in terms of community organizing and get a little bit more micro on you and talk about how to prosecute wage claims, where to prosecute them, what the law is. On behalf of individuals, and I'm going to talk a little bit about how to handle collective actions and what you want to consider when deciding whether or not to take a case as a collective action or move for notice to the class and create a collective action. But most of my speech is going to be on the Fair Labor Standards Act. I'm going to talk a little bit about the Payday Act and common law claims, but most of it's going to be on the Fair Labor Standards Act. And I've got to warn you that really the view that I'm giving you all of the Fair Labor Standards Act today is sort of like, I was trying to think of a visual as I was driving over here this morning. It's sort of like when you log on to Google Maps and you haven't typed in an address and you see the world there. That's kind of what I'm going to give you today. I have an hour and 15 minutes to talk about the Fair Labor Standards Act. And about 2 days before I was getting ready to think about what I was going to say today, I got this flyer from the National Employment Lawyers Association, and they're giving a CLE on the Fair Labor Standards Act that is, Fair Labor Standards Act alone, that is 2 days long. So I'm telling you that both to kind of give you a roadmap as to what I'm going to talk about and to warn you about the Fair Labor Standards Act. Because while I can point to you on that globe where you need to go and what you need to be looking for, you need to follow that down. You need to type in the address, dig down into it, because when we're talking about this particular act, it's the nuance that governs these cases. The nuance is where the rubber meets the road in almost all of these Fair Labor Standards Act cases. And they are, it is a profoundly powerful tool on behalf of workers to combat wage theft in this country. But before I get to the Fair Labor Standards Act, let me talk about the Payday Act let me talk about a few Texas law claims. The Payday Act and common law claims. Common law claims, we all know about breach of contract, quantum merit claims. The thing to know about those is you can get attorney's fees on those in Texas. Under Civil Practice and Remedies Code 38.001, that's very, very important. But it's equally important to make sure that you can get attorney's fees under 38.001. So make sure that you perfect your claim to fees under 38.002. It's not hard, but it's mandatory. If you don't do it, you don't get them. And you lose out. You lose out, your client doesn't, but you lose a powerful tool in helping your client obtain the wages that they've lost as a result of either breach of contract or unjust enrichment. Texas Payday Act, Chapter 61 of the Texas Labor Code. It is sort of like a breach of contract with a few notable exceptions. First, 180-day statute of limitation, not a 4-year statute of limitation. Second, it only covers employees who are in an employee-employer relationship. It does not cover independent contractors that you can obtain relief for under common law claims. The other thing to know about it is if you are able to get the Texas Workforce Commission to find on behalf of your client, you can have the TWC impose a tax lien against the employer, which is a pretty good incentive to pay. The problem with the Payday Act is I have not been able to find an attorney's fee provision in it. And so it's really, it's sort of a summary, quick administrative process that you can use for sort of the smaller wage claims that you're looking at, but so long as it falls within that 180-day window. Now, it's in the last few years, there has been a significant change in the law with respect to the interplay between Payday Act claims and common law claims, and that happened in 2008 when the Supreme Court handed down Egal versus Bright Star. In the old days, it used to be that we could go to the Texas Workforce Commission, follow the wage claim through. If we won, great. If not, we could say fine, go down to the courthouse and file a common law claim based on the same facts. And that was based on a series of appellate court opinions that had held that the two claims are entirely distinct, and so there's no res judicata as a result of pursuing a Payday Act claim before bringing a common law claim. Egal erased those decisions and held that res judicata will apply in cases where the Texas Workforce Commission has jurisdiction over a claim and you pursue it through to a decision by the TWC. Be aware of that. Be aware of that Egal decision before you either advise a client to file a Texas Workforce Commission claim or before you file one on behalf of a client, and follow it through to a decision. And by the way, that Egal case has also been applied at least by one federal district judge in the Southern District of Texas, Judge Lake, who held that an employee who followed a claim through the TWC through a decision, the factual findings by the TWC were binding, were res judicata in his federal case under the Fair Labor Standards Act. So Egal may have broader implications than just barring a common law claim under Texas law. So that's all I have to say about the Payday Act and common law claims. And I'm going to shift gears here on you. I'm going to talk about the Fair Labor Standards Act unless anybody has any questions about breach of contract, quantum merit, or Payday Act claims. Okay.
Real briefly, with the,
Yes.
to perfect attorney fees, is that just the notice to sue letter, 30 days before filing?
It's actually 30 days before judgment, but yes, that's correct.
Before
Yeah,
judgment.
yeah, and there are a myriad of ways to, it's called presentment of the claim. There are a number of ways to present the claim. The one that you cite is the easiest and most effective one in my view. You don't want to have to file an affidavit to say, yeah, I sat down in a room with my opposing counsel and had a conversation, told them exactly what the claim was about. You want to have it in a letter so you can show the court, I perfected the claim and this is when I did it. So that's correct. And they have to, the person has to be represented by a lawyer. You can't have lay people out there going out trying to perfect claims for attorney's fees. Okay. Now, the Fair Labor Standards Act, 29 U.S.C. Section 201 et sec. And the regulations interpreting that act are nothing short of Byzantine. And this is why I warn you, if you have an issue under the Fair Labor Standards Act, I'm pointing you in the right direction. You have to follow the path and learn the nuance of whatever issue it is you're dealing with in any particular case. The FLSA was passed as it was a Great Depression era piece of legislation. It was one of the last New Deal pieces of legislation that FDR was able to get through the Congress that was beginning to backlash against the other reforms he was making at the time, but it was an important one. And as a result of its remedial purposes, anything you do, any argument you make under the Fair Labor Standards Act, you need to bear in mind this little bit of law that has been repeated by the United States Supreme Court over and over and over again, which is it is a broadly remedial statute that is to be construed to the furthest extent consistent with congressional intent. It is an incredibly broad, powerful statute, and you should use it as such and interpret it and encourage courts to interpret it as such. Sometimes they don't. Usually they do. It's sort of changing in the last few years, but we're continuing the fight. Okay, for those of you who don't know, the Fair Labor Standards Act ensures overtime pay at 1.5 times what's called the regular rate of pay for all hours worked over 40 in a work week. It ensures payment of the minimum wage, which is currently $7.25. It has a child labor provision, which is beyond the scope of this speech. It also has a retaliation provision, which you all should be aware of if you file an FLSA action on behalf of a current employee. I have a case right now where I filed a claim, and about 3 weeks later, he wasn't fired, but he had removed from him his ability to do his job. And so now we're looking at a retaliation claim. But there is protection for folks who are retaliated against as a result of filing a wage claim, and that's under Section 215. I'm not going to talk about those cases either. Those are significantly different cases than straight wage claims. Okay. Statutes of limitation. They're a little weird under the Fair Labor Standards Act. The default statute of limitation is 2 years. If you can prove willfulness, you get to go back 3 years. And the statute is important because you get to go back 2 years of unpaid wages or 3 years of unpaid wages. And for every day that goes by, you basically lose a day of unpaid wages. So getting these claims on file as soon as possible is very, very important. Now, in terms of willfulness, what does willfulness mean under the Act? It means that I believe courts instruct juries like this. The defendant violated the Act. When it did, it either knew or should have known that what it was doing, it either knew or showed reckless disregard as to what it was doing was violative of the Act. If you're able to prove that, you get to go back 3 years and not 2. Now, the remedies under the Act are obviously unpaid overtime, unpaid minimum wage, liquidated damages, which we'll talk about here in just a few minutes, but basically liquidated damages is automatic unless the defendant can prove certain things that I'll talk about here in just a moment. But liquidated damages simply means double back pay. So you get double whatever unpaid overtime, double your minimum wage, whatever minimum wages your client has had withheld. And then, of course, attorney's fees and costs. All of these remedies you can find in Section 216B of the Act. Now, again, I've been asked to speak about intake matters and advocacy matters and negotiation and settlement and collecting on judgments and I think anything else you can think about under the Act. And now I have an hour and 5 minutes, or an hour. I had a little trouble wrapping my brain around how to do this because every case is different, and you have to take the facts of every case, what your client is like, and take all that into account. And so it's a little difficult for me to tell y'all how to handle your first wage claim, and it also depends on your own style as a lawyer, how you pursue cases and how you prepare them. So the conclusion that I came to is that if I were sitting in a room and I've never handled an FLSA claim, by the way, how many of y'all have handled FLSA claims? Has anybody handled a collective action under the Fair Labor Standards Act? Yes? In which court?
Well, we've done them here in Austin.
Yeah.
But I also worked at Center for Migrant Rights in Mexico, where we did a lot of opt-in work for counsel across the country. So when migrants went back to Mexico, we'd go across,
Right.
go up to mountains and say opt-in, opt-in, opt-in.
Did you work with a man named Aaron Madoff by chance?
No.
No? Okay. In any event, so if I had never handled a claim before, or even if I had, maybe I'll learn something new. I was thinking that, maybe I'll just give you an overview of coverage issues, who's an employee, who's an employer, who's not, and what are the defenses, and so on and so forth. So that's how I intend to proceed here over the next few minutes. And by the way, this is intended to be interactive, and this stuff is pretty difficult. There's some inside baseball stuff that I'm going to talk about here in just a little bit. But if anybody has any questions or comments about what it is I'm talking about, feel free to jump in and we'll talk about them. I'll try to answer them to the extent that I can, and if I can't, I'll find an answer for you. Okay, the first issue when a person comes to you with a potential FLSA claim is whether or not they're an employee, whether or not they can seek damages under the Act. Only covered employees can seek damages under the Act. Let's talk about the employee side of it first, and then we'll talk about the employer side of it. Employees are those people who are basically have dipped their toe in the course of their work in the stream of interstate commerce. This is a Commerce Clause piece of legislation, and so it's, we go back to that Wickard versus Filburn case, the wheat case, and we, I see a lot of eye rolling, and that's the basis for the Fair Labor Standards Act. So it's a very, very broad statute in terms of its coverage. The other thing that you should know about this is sometimes a person will come to you who works in a large entity who in their particular job, they may or may not dip their toe in the stream of interstate commerce. That person may still be a covered employee based on amendments to the Act from 1961 and 1966, and I think again in 1974. And this is called enterprise coverage. And that's an important concept under the Act. The intent of the enterprise coverage amendments was, again, to broaden an already broad act. The U.S. Supreme Court has, at one point, even before these amendments were passed, talked about how the act is written in such broad language and undoubtedly encompasses people whom Congress did not intend to protect. And so it's even broader than that now. What enterprise coverage means is this. If you have an entity that has at least two people who are engaged, who either move goods through or produce goods for interstate commerce, and that entity has $500,000 in gross sales, I believe. It's not gross revenue, it's gross sales less excise tax and some other stuff. Then that is an enterprise that will cover employees who do not dip their toes in interstate commerce, and those employees will still find the protections of the Act, and that's under Section 203R, I believe, of the Act.
What would be an example of an employee who doesn't dip their toe in interstate commerce?
That's a good question. I was thinking about it yesterday, and I think it would be an employee who is, let's say, somebody who is entirely involved in maintenance work for a large factory who has workers producing cars that will cross state lines. I suppose the broom is not part of the entity's business, right? Or whatever tools they're using for their maintenance work. So I think that person, arguably, under the pre-1961 amendments, would not be covered by the Act. Let me put it to you like this. Before the 1961 amendments, you would have to look at each and every position individually to determine whether or not those particular employees are covered by the Act. Today, it is whether the enterprise is covered by the Act, assuming you have they meet that $500,000 threshold. Does that make sense? Okay. If you have a better example, let me know. That's what I came up with. Honestly, you don't really deal with this much anymore, yes?
Sometimes the example I would give on Know Your Rights trainings is like, if you're a landscaper and you're working for a guy that just drives around in a truck,
Mm-hmm.
and you're just, mowing lawns for residences, I don't know, there might be enterprise issues. But if you're H-2B worker doing the same work for Brickman Corporation, which is a landscaping firm with contracts across the country for hospitals, now you're talking, so the same type of work,
Right.
with different kinds of employers could put you in or out of the system.
That's true. That is absolutely correct. Yeah, and that is correct. I mean, we're focusing on, less on what the employee does when we're talking about enterprise coverage and more on what the employer does, whereas before it was the other way around. And by the way, the FLSA does not cover independent contractors, and there are certain cases under the FLSA called misclassification cases. People can be misclassified as exempt under the Act, not paid overtime when they should be paid overtime and minimum wages. People can be misclassified as independent contractors and not receive overtime or minimum wages under the Act when they should receive them. And this happens actually quite a bit. There's a lot of litigation going on right now with exotic dancers, where the exotic dancers are classified as independent contractors, and they're not even being paid the minimum wage some nights. And there are just a slew of these cases being filed across the country over the last 3 or 4 years. And so that's one type of misclassification, but I want to draw your attention to it because, again, the Fair Labor Standards Act only covers employees in an employee-employer relationship, and nomenclature doesn't matter. Just because an employer says you're an independent contractor doesn't mean you're an independent contractor. Courts will look behind the transactions going on, and they'll apply what's called the economic realities test. And the cases you need to be aware of here, there's a U.S. Supreme Court case called Silk versus United States, and there's the Brock case out of the Fifth Circuit, which is a 1987 case, Brock versus Mr. W. And then there is a more recent case from July of 2012, actually, out of the Fifth Circuit, that also talks about the economic realities test. And I'll talk about that case with respect to something else a little bit later, but that case is called Martin versus, yes, thank you, Spring Break 80-something or other. Spring Break 83 Productions, yeah. You might. sort of develop your own ideas as to what they did. And really at the end, at the end of the analysis, when you're talking about whether somebody's an independent contractor or an employee under the Act, the issue is whether the employee is economically dependent on the employer. And the Fifth Circuit has set forth a 5-factor test to determine that. Although in Martin, I think they have pared it down to 4, if my memory serves correctly. The definitions under the Act, under Section 3, 203, with respect to employee and employer, just like just about everything else under the Act, they're extraordinarily broad. Employ is to suffer or permit to work. An employer is any person acting directly or indirectly in the interest of an employer in relation to an employee. I don't know how Congress could possibly have written that definition any broader, or those definitions any broader. And so if you've determined that you have an employee, or that you have colorable arguments that somebody is an employee who's been misclassified as an independent contractor, you also need to, if you determine, let me back up. If you determine that the Fair Labor Standards Act covers the employee and the employer in the case you're considering taking, the next question is, if they have been misclassified, if they've been classified as exempt and not paid overtime, not paid even minimum wages, because non-exempt or exempt employees are not entitled to minimum wage, they're not entitled to overtime, they're exempt from the protections of the Fair Labor Standards Act. Well, they can be misclassified as exempt. They can be non-exempt and be called exempt. There is a tremendous amount of litigation surrounding the exemptions. And the exemptions under the statute are at Section 213 of the statute. And the most significant exemptions under the statute are the executive exemption and the administrative exemption. The executive exemption typically arises in those cases where an employer just says, you're a manager, doesn't give them any managerial duties, pays them a salary, and works them to death. And they rely on the executive exemption to say, no, I did this within the Fair Labor Standards Act, I'm protected by the law. The administrative exemption has to do with people who make significant decisions on behalf of organizations. There's a lot of litigation about that exemption, but these are just certain examples of exemptions under Section 213, and actually those two arise under 213A1. But if you read through Section 213, which is a fairly long section of the statute, you'll see that there are all sorts of exemptions that you can't understand why they're there. Some of them you can. Some of them you just kind of scratch your head and wonder who thought of that. Like there's one exemption for newspaper delivery people who deliver papers in geographical locations with some certain size of population or less. So there are very, very specific exemptions. Look at the exemptions before signing up any case. Look at all of them. You also need to look at the regulations on the exemptions, because those define the exemption, particularly for the executive and the administrative exemption, the professional employee exemption, the computer employee exemption. And those are going to be under, the ones I just rattled off there, under Part 541 of Title 29 of the Code of Federal Regulations. And just basically, those regulations set out tests. You may have heard the short test and the long test for executive exemption and administrative exemption. Those have been done away with. You don't have to worry about short tests and long tests, and if you see cases discussing them, those are under the pre-2004 regulations, I believe. The regulations were amended under the Bush administration in 2004. You might remember there was a bunch of hoopla about that, particularly for computer employees back then. But you really want to go through each and every element of the exemption and make sure that the employer involved in your case fails one of the elements. And some of them are binary inquiries, meaning the employee either does or does not. For instance, the employee must be paid a salary of at least $455 a week here in the continental United States. They're either are or they're not paid $455 a week, and if they're not, the employer fails the salary basis test, and they're not exempt, and they're misclassified. Another one is they supervise 2 or more employees a week. Now, there's some litigation over, well, what does 2 or more employees mean? Most courts interpret it to mean 2 40-hour employees, or they apply something called the 80-hour rule, meaning I supervise at least 80 hours of employee work a week. Again, the employee either does or does not supervise 80 hours a week. There could be some litigation over that, but you can look at time records and schedules and nail that down pretty objectively. And then there are the gray area elements, like under the executive exemption, the primary duty of the employee must be management of the enterprise or a department of the enterprise. Well, whether management is the primary duty is it produces tremendous amounts of litigation. And in fact, even cases that are certified as collective actions, which again I'll talk about here in just a little while, even cases that are certified as collective actions are now going to trial more and more over that issue than they were in the past. It used to be you get the case certified as a collective action and it would settle soon thereafter. Not anymore. Employers are trying these more, and I'll talk about trial here in just a little bit. Now, the good thing about the exemptions for employees is the exemptions are an affirmative defense. This is one reason the FLSA is so powerful for employees. There are very few areas in the law where the employee is actually doesn't have the burden of proof. This is one of them. And not only does the employer have the burden of proof, it's a significant burden of proof that the employer has to prove. In other words, the employee is presumed to be exempt, or excuse me, presumed to be non-exempt under the law. If an employer wishes to fight a lawsuit, it has to prove that, in fact, they are exempt, and it has to prove each and every element of whatever exemption you're talking about. Case law is clear. The exemptions are narrowly construed against the employer, and the employer must prove that the employee is plainly and unmistakably, that's a quote, plainly and unmistakably exempt from the protections of the Act. Beware of an argument that I expect to be made in the near future on these cases based on a footnote 21 from a case called Christopher versus SmithKline Beecham that came out. It's a United States Supreme Court case, came out last summer. And the footnote discusses this plainly and unmistakably language and poo-poos it a little bit, suggests it kind of poo-poos it. The language is dicta, first of all. But the argument that the Supreme Court ultimately rested on to not apply plainly and unmistakably was based on some statutory language in the definition section of the Act. So I think when you're talking about the run of cases, the vast majority of cases, you're going to be able to distinguish Christopher, footnote 21 from Christopher, because usually you're not talking about what a particular specific discrete definition under the Act means with respect to how it applies to exemptions under Section 213. It's a little difficult to discuss in the abstract, but if you go look at the footnote, I think you'll understand, and read the case, which is kind of beyond the scope of this topic, this talk, you'll understand what I'm driving at here. But that doesn't mean that a court won't apply footnote 21 to abolish the plainly and unmistakably standard and make proof of the exemptions a little bit more easy, a little bit easier for employers. Just be aware that that footnote 21 is out there. So, you've taken the case, you've determined that the employee is covered under the Act, the employer is covered under the Act. You've determined that you have at least colorable arguments that this person was misclassified either as an independent contractor or as exempt under the Act and should have been paid overtime but wasn't. Or should have been paid minimum wages but wasn't. What do you get? Well, minimum wages are easy. I mean, they're either paid $7.25 an hour or they weren't. And you get the difference for each hour worked of $7.25 and whatever they were paid. And then overtime for all hours worked over 40 in any particular work week based on a regular rate of pay of $7.25. Unpaid overtime, what you should be aware of as a practitioner looking at these cases. Overtime calculations can get unbelievably complicated. There are case after case after case out of the U.S. Supreme Court where employers have been tried to craft compensation agreements with their employees that just walk up to the line. Don't quite cross it. Some of them cross it, some of them don't. But they are endlessly creative, and some of them are nasty. But how to calculate unpaid overtime in any particular situation, whether we're talking about somebody paid on a day rate, somebody paid for piecework, an hourly worker is easy because the hourly rate is the regular rate. But piecework, day rate, salary basis, any of the myriad ways that you can think of to pay an employee, there are ways to calculate unpaid overtime. And oftentimes, how to calculate unpaid overtime becomes an issue for litigation. In fact, it becomes the issue for litigation. And I actually have a case up on appeal right now talking about that particular issue about fluctuating work week, which I'll talk about here in just a moment. But just to orient you, to point you on this globe where to go to in order to determine how to calculate damages for unpaid overtime, I would point you to Part 778 of Title 29 of the Code of Federal Regulations. I'm sorry I didn't put this on my outline. I should have. But Part 778 discusses the different ways to calculate overtime compensation. You should know that 778 is what's called an interpretive bulletin. It's not a regulation, meaning it didn't go through the notice and comment period, and so it's not entitled to Chevron deference. I don't know how many of y'all deal with regulations that talk about Chevron deference and Skidmore deference and all that deference, but these are not entitled to Chevron deference. In other words, they are not considered as authoritative as Part 541 discussing the exemptions, for instance. Those are regulations. Just be aware of the difference between interpretive bulletins on the one hand, regulations on the other. Okay. I want to come back to fluctuating work week here in just a moment because it's an issue that I've spent a lot of time on recently, and I want to orient you all to the issue so that you know how to combat it, and I've given you a paper on that. But let me hold that in abeyance just for one more moment and talk a little bit about liquidated damages under the Act. Liquidated damages, again, if you have an employee who you've determined is entitled to overtime compensation, and you get a judgment, say, or you get a jury verdict or a bench trial finding, the court must double that amount. Must double it. The statute says the court shall award an equal amount as liquidated damages. In 1947, Congress passed the Portal to Portal Act, which allows the employer to assert an affirmative defense to liquidated damages. And in order to avoid liquidated damages, once again, it's the employer's burden. In order to avoid the imposition of liquidated damages, the employer must prove that it violated the Act reasonably and in good faith. By the way, if you get a willfulness finding, they cannot prove that as a matter of law. Cannot prove it, and that makes sense. If the employer knew or showed reckless disregard as to whether or not they were violating the Act, they certainly can't prove they violated it reasonably or in good faith. And you should note that the reasonably or in good faith standard has an objective component and a subjective component. And so just be aware of that. And even the Fifth Circuit has repeatedly held that the burden to avoid imposition of liquidated damages is a quote, substantial burden, end quote. And so it's a little difficult when you're on the intake end of things to determine how you're going to fare on the liquidated damages argument, because whether or not an employer reasonably or in good faith violated the law really depends on the steps that the employer took prior to misclassifying the employee as independent contractor or as exempt under the Act. And you don't know what the employer did most of the time. But once you get into discovery, you usually find that the employer says, well, I went and looked at the regulations. I went and looked at the regs. Well, then you have to ask, well, which regs did you look at? Were they before 2004 or after? Did you consult with a lawyer? That's pretty good evidence that they had a reasonable basis or took their, misclassified somebody in good faith. But again, on the intake end of it, you just got to take throw a dart at a dartboard and make a reasoned decision about the risk on liquidated damages. And really, dart at the dartboard is overstates the case a little bit. When you usually know a little about the employer before you take a case, and you can usually determine whether or not particular employers are sophisticated enough to have consulted counsel about whether or not somebody's exempt or non-exempt or an independent contractor or not. And so just make an educated guess on that. That is a little bit more risky until you get into discovery. Now, I want to talk to you about fluctuating work week. I've given you a paper that I wrote last year, probably in May, I think I wrote it. Fluctuating work week is a method of paying overtime to non-exempt employees. And it particularly applies in cases where the employee is a salaried employee. And usually where you will see it is in cases of mid-level managers in some industry, usually the retail industry, where they're paid that $500 a week salary and worked 100 hours. And here is the key to fluctuating work week cases. If you remember nothing else from this seminar, and you look at a case and you think that there may be a fluctuating work week issue in it, in other words, is the employer going to claim that overtime should be paid according to the fluctuating work week method because an employee is paid a salary and their hours fluctuate from week to week? The key to these cases is, what was the compensation agreement between the employer and the employee at the time employment began? Stated another way, what was that salary intended to compensate? For what number of hours was that salary intended to compensate? The answer to that question will determine how damages are calculated, and unless that compensation agreement was for unspecified or for any and all hours worked during the work week, fluctuating work week does not apply. And let me demonstrate to you, let me just give you an example as to how pernicious this doctrine is, fluctuating work week. And I should also say it's in vogue on the defense side of the docket to argue in every salary case that fluctuating work week is the method to use to calculate damages, and here's why. Let's say you have an employee who's making $500 a week, and they work 40 hours a week. Their regular rate of pay is 500 divided by 40. If they are making $500 a week and they work 50 hours a week, their regular rate of pay is 500 divided by 50, or $10. And then in order to calculate overtime, because you've then exceeded the 40 hours in a work week, the employee is paid 1/2 of 10 for all hours worked over 40 in a work week. Not time and a half, 1/2 of 10. The theory from the ivory tower courts on this is that, well, they contracted to work for that salary for all hours worked during the work week. Therefore, they've already been paid at straight time for all hours up to 50. And so they're paid one half their regular rate of pay, or $5 an hour, for every hour worked over 40 in the work week. Draw that out to 100 hours. Their regular rate of pay is $5, and they're paid $2.50 for every hour worked over 40 in a work week. Now, I'm not going to drill down into the math for you on this. As soon as the employee hits 60 hours a week, it actually becomes cheaper for the employer to work that employee longer, more than 60 hours in a week, than it is for the employer to hire another employee to do the same job. This is very important because one of the two reasons for passage of the Fair Labor Standards Act was to spread employment among the workforce. So it is totally contrary to that. The other reason, of course, was to eliminate the evil of underpay for overwork. It is also contrary to that. In other words, under fluctuating work week, the harder and longer an employee works, the less that employee is paid. That's why this is so important. And these cases, again, turn on for what number of hours was the salary intended to compensate. Fluctuating work week only applies in the case of unspecified hours, or this salary you were receiving, employee, for any and all hours worked. Just as an aside, I have a case up on appeal at the Fifth Circuit on this very issue right now. It's a case I tried with my good friend David Weiser, who some of you may know, in November of 2011. And the testimony at trial was consistent. We were hired for a minimum 55-hour work week, and we were only paid a salary. Well, in reality, what ended up happening is some of my people worked 104 hours a week, often over 90, sometimes less than 55, almost always more. And the district court found that the salary was intended to compensate for 55 hours in a work week. And so you calculate the regular rate of pay by dividing the salary by 55, and the judge then awarded 1/2 time for all hours worked between 40 and 55. So 1/2 0.5 overtime premium. And then for all hours worked over 55, because they had contracted to work for 55 hours for their salary, for all hours over 55, they were awarded 1.5 times the regular rate of pay. The employer argued that although they were hired for a minimum of 55 hours, because they ended up working more or less during the week, fluctuating work week should apply. I think we have the better of the argument, but the Fifth Circuit will decide here, hopefully in the next few months. The case is called Ransom versus Impetel Enterprises, Inc. But in terms of other arguments to make to defeat this doctrine that is, to me, is legally sanctioned wage theft, take a look at the paper to defeat the argument. And I need to be clear here. There's a difference between paying non-exempt employees and doing it properly. You can actually pay non-exempt employees under the fluctuating work week method and not run afoul of the act. What I'm specifically talking about is courts using the fluctuating work week method to fashion remedies. There's a difference between fashioning remedies and looking back and saying, well, you should have been paid this, and an employer and employee, through whatever mutual bargaining can happen outside of the union context, the employer and employee negotiating for a fluctuating work week pay scheme, and that agreement being prospective in nature. The prospective agreement is legal and sanctioned under Part 778. It's actually specifically Part 778114 of the Code of Federal Regulations. That's not what I'm talking about. I'm talking about courts using that 778114 methodology to apply, to remedy unpaid overtime from years past. But in any event, if this is pretty technical, this is the inside baseball stuff I was talking about. I've spent so much time on it the last really year and a half that I would be remiss if I didn't talk about it. And it's become an important topic to me personally and professionally. And if anybody has any questions about it, I'm happy to answer them to the extent that I can. But if not, I'll move on. But just be on the lookout for the ransom case that's coming out, hopefully fairly soon. Okay. The last thing I want to talk about in terms of advocacy is trying these cases. Like I said earlier, traditionally, not many of them, particularly if they're certified as collective actions, are tried. That ransom case is an exception. We had it certified as a collective action, and we had to try it. The defendant made it easy to try by making, with their offers of settlement, they made it easy to try. And so we tried it, and we got a verdict. And after I tried it, I actually learned that there was my good friend in Dallas, Joe Gillespie, tried a misclassification case before Judge Kincaid in the Northern District. And I've heard of, and that was, again, the same week, and I've heard of another case out of the Southern District of Indiana, also tried, another misclassification case, also tried that same week. And to me, I don't know of any other week where so many misclass cases under the Fair Labor Standards Act were actually tried. But I think it's indicative of the defense attitude. They actually think, they're starting to think they can win these. And by the way, they lost all three of those cases. But that doesn't stop them from trying them. I think that these cases, this isn't a trial advocacy course, but I think just in terms of trial advocacy, these cases give you the themes pretty much from day one. The themes are fair pay for long hours, fair pay for hard work, fair pay for, just whatever variation on that theme you can come up with. And this is a theme that resonates not only among people, but across millennia. You can find references to this in Leviticus and Deuteronomy, in literature from across the globe and across the millennia. You want to be careful about using Leviticus and Deuteronomy in front of any jury. Know your jury before you make the argument, but just know it's there and it does resonate. These themes resonate. And again, obviously, themes are, to me, one of the most important aspect of trying and preparing any case for trial. The other thing that I think is important when considering whether or not to try these cases is, remember, this is a federal act. And while you have the right to file in state court, you will almost certainly be removed to federal court. And when you get to federal court, your ability to try the case like you think you need to or want to is severely hamstrung. This is one reason I said earlier there are extraordinarily good reasons to be in state court under common law claims in the Payday Act. But one of the major problems, in my view, in trying cases in federal court is you either don't get any voir dire. Is there anybody not from Texas here? Okay, voir dire, that's what it's called. Either don't get voir dire in federal court, or you are significantly limited on it. I've had, in the ransom case, Judge Austin gave us 30 minutes aside after conducting most of the voir dire himself, which I thought was generous for federal court. I've had another federal magistrate judge give us unlimited voir dire, which was extraordinary. And then I've had another one, a district judge, give us 10 minutes. It just depends on your judge. Just know your judge if you end up in federal court. Because, again, not a trial advocacy course, but particularly in collective actions, when you have a number of people and a number of personalities and life is messy and more than one life is messier, you're going to want to discuss your problems in your case with the jury early on. And I always do that in voir dire. But just be aware of, federal court attitudes toward voir dire. That's all I have to say about trying these cases, unless anybody has any questions about that. I can relate my experience on it, but okay. when you have one or more people who come to you who've not been paid their wages and you determine that they're non-exempt and they're misclassified and so on and so forth, one of the things you want to probably consider is whether or not you you have the opportunity to create a collective action from however many people are sitting across the desk from you. These can be extremely powerful in terms of convincing a defendant to pay your clients what they're owed. Because two people might give the defendant some concern, but 100 people certainly will give the defendant some concern. Because these cases, even though individual wage claims might be relatively small, collectively, they're not. Particularly when you're talking about liquidated damages at the end of it and attorney's fees. So you want to look at Section 216B of the Act. And there are a few, I cannot possibly cover collective actions in any detail here, but I just want you to be aware of a few things. These are class actions. If you go look at docket sheets of federal courts who have certified collective actions, they're called class actions. They are not Rule 23 classes. There are significant differences between Rule 23 and 216B classes. One of the most significant is these are opt-in classes. And so when the potential class members receive notice of a collective action, they're not, unlike Rule 23, automatically in the class and have to opt out if they want to do something on their own. They have to affirmatively opt into the class. They have to confirm to the court that they are probably in this class and probably deserve to be paid something, and they file their notices of consent, and they're then party plaintiffs in the case. In order to get the court to certify a collective action, the court is almost never going to certify it sua sponte based on the complaint that you filed. You have to file something called a motion for notice under Rule 216B. And you want to file that expedited because all those people who are potential class members out there, for every day that goes on, they're losing a day of pay if they work there for more than 2 or 3 years. Now, the Fifth Circuit has never specifically ruled on the standards for whether or not a district court should grant class notice in these cases. The closest they came is in a 1995 case called Mooney versus Aramco. And I believe in the Mooney case, the Fifth Circuit referred to a 1980s District of New Jersey case called Lusardi versus Xerox, I think. And the Lusardi dance is what I call it. The Lusardi case has sort of become the standard by which most district courts determine whether or not collective actions are appropriate in any particular cases and whether or not it should go ahead and approve sending out notice to potential class members. In the first stage of the Lusardi dance, the plaintiffs, one or more plaintiffs, will file a motion for notice. The earlier you can get that done, the better. I usually have my motion for notice ready to go or almost ready to go before I even file the original complaint. Earlier, the better. Because there are 2 stages under this Lusardi dance, and where stage 1 ends and where stage 2 ends is subject to debate. It's not subject to debate if little or no discovery has taken place, and that's usually when I file the motion for notice, either at the same time or soon after I send my first set of written discovery. The reason you want to do it early is the different standards for class certification. Early motions for notice are judged on what's called a lenient standard. That phrase occurs across the jurisprudence, the cases on collective action motions or motions for notice. It is a lenient standard that the district court uses to determine 2 things. One, whether there are similarly situated employees with respect to their job duties. And 2, whether those employees are also similarly situated with respect to how they are paid. And if those 2 issues or if those 2 elements are satisfied, usually, then the court will grant notice in a particular case and allow you to send notice to potential class members, and it will at the same time order the defendant to tell you who each of these class members are. Again, this is the power of the Fair Labor Standards Act. You have a lenient notice standard to determine people who could be across the country, who could be owed wages based on the same set of operative facts that your clients have not been paid, and if so, you can get relief for them as well. And the second stage, so I talked about two stages of the Lusardi dance. The first stage is the lenient standard stage. The second stage occurs after discovery has taken place. At that time, the defense can, and sometimes they don't, but they can file a motion to decertify the class because discovery has shown that certain people, or all of the people, are not similarly situated to the plaintiffs in the case. And that the most significant case that I know that that's happened on in the last several years is a case called Johnson versus Big Lots out of the Eastern District of Louisiana from 2000. I think that opinion was written in 2008 by Judge Vance. But that gives you a pretty good roadmap of what a sophisticated defendant will do to avoid collective actions under the Fair Labor Standards Act. And on the flip side of the coin, the most significant case that has actually been tried as a collective action is the Morgan versus Family Dollar case, which was taken up to the 11th Circuit and affirmed, and I believe that was a $34 million verdict for the class in that case. There are several considerations there are several things you should consider in filing these motions for notice in order to certify a collective action. First of all, does it make sense? Is it worth your time to go through the process of filing the motion for notice? Because you can't just file a motion for notice without any sort of supporting evidence. You have to have affidavits from your clients saying, I'm aware of folks who are similarly situated to me, this is how I'm paid, and this is how I believe they're paid. By the way, the standard is for substantial allegations of similarly situated in terms of job duties and in terms of compensation. I like to find either a former HR manager, and by the way, this all happens as part of my investigation into these cases. I don't file the lawsuit and then go out and look for the former HR manager to talk to them, or the HR manager. So if you're worried about ethical considerations under Rule 4.02 and whether you can engage in ex parte contact, 4.02 only applies in cases where you know the person or the entity that they're an agent of is represented by counsel in an action. If there's no action, 4.02 doesn't apply. And so sometimes what happens is you will get somebody just may call you out of the blue, which has happened to me, and say, I'm a former HR manager and I happen to know that all of these people are paid the same way. That's pretty good evidence of similarly situated in terms of compensation. Sometimes that doesn't happen, but when it does, it makes getting the motion for notice a little bit easier. And getting back to the issue of whether it makes sense to file a motion for notice, if you don't know how many potential class members are out there, it might make sense to file the motion just to find out. If you know how many, or you have an idea of how many potential class members are out there, but your client group or people who come to you after the lawsuit is filed and who opt in without having to receive notice, because people don't have to actually receive notice from the court that there's a lawsuit in order to opt into the class. They can opt in of their own accord. If you have an idea of how many people are out there who might be in the class, and you look at it and you figure you have 25% or more of the potential class already opted in or who have already contacted you about whether or not they're interested in it, then it may or may not make sense to file the motion for notice, because you're usually not going to get more than a quarter or a third of the potential class members opting in for whatever reason. Personal reasons, they're across the country, they don't want to make waves with their former employer because they want a letter of recommendation. Whatever the reason, if you get to 25% of the potential class, you probably are just about at the limit of what your class is going to be anyway, and getting those marginal people on board doesn't justify the expense of going through the notice process. There are ethical considerations with respect to the class members, not like Rule 23 classes, because these are opt-in classes and it takes an affirmative act by the potential class member to get into the class. But there are still ethical considerations that you should think through. I'm not going to go through those here, but there are ethical considerations that you should seriously think through when deciding whether or not to file a motion for notice. And David mentioned this in his speech, but if you have more than one plaintiff, of course, get a joint representation agreement that talks about the 1.06 matters and potential conflicts. You should just be doing that as a matter of course. The other consideration, do you file a motion to toll the statute of limitation? Because while the court is considering your motion for notice, the statute of limitation is running for all these people who don't know the case is out there. I'm of two minds on this. Honestly, I've never seen a motion to toll the statute of limitation actually granted. And sometimes you just don't have the evidence to sign a document to sign a pleading under Rule 11 under the law of the Fifth Circuit. Oftentimes you don't have that. So that's a case-by-case consideration, but that is something to certainly consider if you're thinking about filing a collective action. Do I want to toll the statute for potential class members? And then the other thing is, do you file in state or federal court? If I know that I'm going to try to certify a case as a collective action, even though I much prefer to be in state court, I go to federal court immediately, because you're going to lose a month or more, more than a month, while the defendant removes your case, because they will inevitably remove it to federal court. So state or federal court, collective action, always federal court. Go ahead.
Why is that?
Why do they remove?
Yeah, is it just motion for summary judgment? It's just easier to get a motion for summary judgment in federal court?
Exactly. Motion for summary judgment and less of an opportunity to try your case. But summary judgment is the big draw to federal court.
In your experience, I mean, how much, just kind of out of curiosity, my understanding, and I don't do a lot of civil, motions, but that, state courts will just basically rarely, if ever, they're gonna let you get to trial. And just anecdotally, from people that do practice, federal judges just will never, they will never ever, they're gonna toss your case on a motion for summary judgment, like, the vast majority of the time. I mean, is that kind of your...
I think that's a little too categorical on both sides. State judges, in my experience, are less willing to grant summary judgment, even when they should. But I think state judges, state district judges will grant summary judgment if, for instance, you can't prove a prima facie case. Those are really the only instances they'll grant summary judgment. Because remember, a denial of summary judgment is not appealable, and they're also elected. Which is that's beyond the scope of this talk. Federal judges, and remember, you're dealing with different rules, slightly different. I mean, Rule 166A under the state rules and Rule 56 under the federal rules are different. And federal judges are more willing to grant summary judgment. They just are. I don't know why. But they are, and it's a danger in these cases. But if you have, because the defense in these cases often have the burden of proof on the most significant issues, the chances of them getting summary judgment and proving every element beyond peradventure, that's the standard in the Fifth Circuit. To get summary judgment on an issue on which you have the burden of proof, you have to prove each and every element beyond peradventure. Use that phrase often if you get hit with one of these. They have to prove beyond peradventure every element of every exemption that they're claiming, or of one exemption that they're claiming in the case. So I'm a little less worried about summary judgment in these cases. However, you are right, because typically it's a knee-jerk reaction on the part of defendants to want to get to federal court no matter what the case is about.
And is it just kind of, again, from my knowledge of civil, if you beat the MSJ, you've got settlement value. Is that kind of the same, with the FLSA cases where, or are you trying to get that liquidated damages? I mean, And what's kind of the,
Well, that removes a significant risk hurdle in your case, because if your summary judgment is granted, your case is done. So yeah, once you get past that, you're past that risk. And the risk becomes one only of trial. And remember, if the court has granted summary judgment on the underlying case, liquidated, you don't worry about liquidated damages because they're gone too. But the flip side of that is, if you get past summary judgment, the defendant starts worrying about liquidated damages, because that's a real possibility. It's all about risk analysis when you're talking about trying to settle these cases. And yeah, getting past summary judgment eliminates a significant risk hurdle in federal court. So this is a good segue, negotiating wage claims. And when you have a collective action, you settling them becomes a little hidden. I mean, maybe you can share your experience on these if you're willing to, but settling them is a little more complicated than settling a case on behalf of a single client or even multiple clients. Because typically what will happen is the defense will offer, they won't break out the class, because that would require making, multiple, sometimes many offers of settlement. And so they'll offer one lump sum, and then it's up to you to figure out how to divvy up that lump sum. And what I have done, and what I do, is enter into an agreement with my clients at the front end under the contingent fee agreement that based on my calculations, and remember, overtime calculations, while they're subject to some debate as to which calculation should apply, once you decide which calculation applies, the calculation is fairly objective. It's math, right? I mean, you can't argue about it too much. And so I do the calculations for all my clients in Excel spreadsheets, which are infinitely malleable, by the way. Great tools on these cases. Do the calculations for my clients, and then whatever the settlement amount is, the clients will receive a pro rata portion of the net proceeds, and they will be responsible for a pro rata portion of the costs. Pro rata based on what they would have obtained had they gone all the way to trial and gotten a judgment, and so on and so forth. Does that? I can't think of another way to do it. If somebody has a better way, let me hear it. Okay. Now, 4B in my outline before July of 2012 would have been really easy. I would have told you that any settlement under the Fair Labor Standards Act is probably not enforceable unless it's approved by the Department of Labor or a court. For individual actions, that may not be correct in the Fifth Circuit anymore. The Martin versus Spring Break 83 Productions case, if you're going to take these cases and settle them, at least as individual actions, you need to be aware of the Martin case. That case holds that, that case held that the employees in that case did not have to get court approval of the settlement of their Fair Labor Standards Act claim. You should be aware that that case has had cert denied on it recently. And the facts of that case are arguably distinguished from just about any other case you're ever going to see in this situation. Because what happened in that case is there were these employees with a legitimate dispute as to whether or not they were owed overtime. They were represented under a collective bargaining agreement by a union at the time, and they subsequently went to a lawyer. So there were two layers of advice and recommendations being given to the plaintiffs in the Martin case. And then based on that, the district court, I think it was transferred to a district court in Louisiana from a district court in California. And the district court in Louisiana held that a previous settlement agreement under the Fair Labor Standards Act was enforceable against the plaintiffs, even though they didn't get DOL or court approval of that agreement. But to me, it was enforceable on the facts of that case because they had a union and they had legal representation at certain steps along the way in the case. This case is important because let's say you have a potential class of people that you want to have opt into your case. If Martin stands for the proposition that all individual settlement agreements under the Act are not are enforceable even though you don't have DOL or court approval, then arguably the defendant could go out and start picking off each of the individuals who could ultimately opt into your case and pick them off for amounts that are not what they should be paid because they don't have legal representation or they don't have a union backing them up. So you can argue in that, if that occurs, you can say, well, there was going to be a collective action, and Martin does not apply to collective action. It only applies to individual actions. But still, I could imagine a panel of the Fifth Circuit. I can see certain members of that court holding that Martin applies in that situation. And so the case is dangerous. So just be aware that Martin is out there. And by the way, approval by a court or the Department of Labor is really something the defense wants, right? Because they're more worried about the case coming back to them later on if a court doesn't approve it or the DOL doesn't approve it. So if the defense is willing to rely on Martin, I don't know how much you should fight about that on behalf of your client. Again, difference between individual actions and collective actions as to whether or not a court or the DOL must approve. Collective actions are unchanged, in my view, by Martin. Martin, it dealt only with individual actions. So I think that if you have a collective action, you still have to have it approved. It's going to be approved by the court that you're before. And oftentimes that'll happen under seal, and the court will either approve or not approve or approve with certain conditions. So just be aware that you're probably going to have to get approval if the defense asks, if the defense asks for that, you should work with them to craft the documents. Don't let them do it themselves. Okay, the last thing that I know I'm almost out of time here, but Brian included on my course description collecting on the judgment after you've tried it and won, and I'm going to speak to you from personal experience. So, and I'll tell you what I did in the ransom case just a little bit. But there's Rule 64 of the Federal Rules of Civil Procedure is extraordinarily powerful if you're in a state like Texas, which has some pretty good extraordinary remedies in order to collect on judgments. And look at chapters 61 through 64 of the Texas Civil Practice and Remedies Code. And in particular, I would draw your attention to the garnishment statute. If you know where your defense banks and you have a judgment, you can basically freeze their bank accounts with the garnishment statute. Be careful, however, because there are remedies in the event that you freeze the wrong bank account or that you serve a writ of garnishment on a bank for which that person no longer banks. So just be sure that you're banking or that you're garnishing the right bank account, because that could be bad. One thing that I have personally used is I had come across some information that right before the court entered judgment for my plaintiffs, there was a significant movement of money into a homestead by my defendants. Oh, and this is one thing I didn't talk about very briefly. One of the cool things about the Fair Labor Standards Act is you can sue individuals in certain situations if they are employers under those extraordinarily broad definitions under the Act. That is important if you're suing a closely held corporation that you think may roll up upon obtaining a judgment, because you can get individual liability against the principals of the corporation. But in any event, very quickly, so I had indication that there was money moving into a homestead, and I almost within a few days moved to have a receiver appointed, which would have taken over their business. And this happens a lot when you're dealing with overtime claims, because you're often suing closely held corporations, and they can basically do what they want with impunity. And so you're always worried about them rolling the corporation up in bankruptcy or whatever, which is not good for anyone. But I had this information, filed the motion to appoint a receiver, almost immediately got a Rule 11 safe harbor letter, which was never filed. And then within a few weeks, the district Magistrate Judge Austin wrote an order saying, secure the judgment now, or and when you do, or secure the judgment by a date certain by depositing X number of dollars into the court registry, and once you do, the motion for to appoint a receiver will be denied. So I didn't actually have to go through the process of having the receiver appointed, but it was very, very powerful to force them to secure your judgment, which is, once you get the judgment, the work isn't over. You have to make sure that the money is there. So in any event, I see Brian standing in the wings, and I'm going to hand it back over to him. Thank you all very much.
Let's give a round of applause for Brian McGivern.
Patty always gives very flattering introductions. It's funny, before Edmund got started, that he speculated that he had drawn the short straw in terms of the scheduling. And I just want to point out that I'm on the stage after Patty, and after a movie, and after David, and after Edmund. So I'll have to beg your forbearance in being the least glamorous presenter today. And also, my co-presenter, Chris Kaiser, is at home with the flu, which is unfortunate. He did a lot of the heavy lifting to make all this happen today, but hopefully he'll be better soon. So my presentation is what to expect in JP Court. The first question you may be asking yourself is, why consider that at all, especially in light of what Edmund just told us about the real opportunities in FLSA claims. Well, it presents a few opportunities. One, particularly if it's a useful venue if the FLSA is not applicable, and particularly if you're looking for a quick resolution. So very often we've used it with people who are indisputably independent contractors because they're roofers or something like that. And so they really have a breach of contract claim for something within $2,000 or $3,000. And as Patty mentioned, given your clientele, often the flow of money is really important to them. They can't wait. Waiting 2 years for this money, it's going to feel like a windfall when they get it, but that's means nothing to them right now. Getting it 2 years in the future. One of the benefits of JP Court is that you can file and get a trial within 3 months. The other benefit, if you go through the by virtue of the small claims route, is through assisted pro se litigation. That is a big movement, big undercurrent right now within the poverty law community. Areas of the law in which you can provide limited, what's called unbundled services to a client to help them navigate the legal system. The virtue of that being, if you're in a private law perspective, you can offer them a service that they can actually afford that will be useful to them. Or if you're in a nonprofit perspective, being able to maximize the number of clients you're able to serve with your resources. Either way, it's often a very useful resource depending on the type of case and area of the law. This would be an example of that. A lot of, if you have like a straightforward case where it's one person and one employer and they are fighting over one sum of lost money, and that can be really the perfect case for small claims court. So moving on to explain JP Court, small claims court itself, really the only way to do that is by contrasting it to some of the other courts you could be practicing in. And I'm assuming most of you have some exposure to that. Just as a quick overview, some of the things you should know about. Texas Rules of Civil Procedure. There are a special set of rules for Justice Court. It's Rule 523 through Rule 591. You'll also, to gain some perspective, you can look at Government Code 27 and Government Code 28, which respectively govern Justice Court or Small Claims Court. And just to take a step back, Small Claims Court is just like a term for a specific docket that the JP runs. It has a specific set of procedural rules attached to it that I'll get into, but it's the same person, it's the same building. Something particularly useful for these types of cases is Government Code Chapter 57, which says that if you file a motion in court asking for an interpreter for your client, whether that be for a foreign language or for sign language, the judge has to appoint one. Now, there's an open question about who has to pay that bill, but If you have an affidavit of inability to pay costs on file, which is something provided for under Rule 145 of the Texas Rules of Civil Procedure, there shouldn't be any question that your client is not the one that has to pay for that interpreter to show up. Rule 145, the affidavit of inability to pay cost, is extremely useful in a number of respects if you're representing someone who qualifies. You're allowed to waive the filing fee, service of process for the initial lawsuit, any fees for serving subpoenas, at least through government mechanisms, which would be like a constable or through certified mail from the court. You don't have to pay for the abstract of judgment. You don't have to pay for the writ of execution. Keep that in mind. Under Rule 544 of the Texas Rules of Civil Procedure, and bear with me, I'm not just going to run through these rules. You can make a jury demand with as late as 1 day before your trial in Justice Court for $5. And all appeals from Justice Court are de novo. De novo appeals to county court where you get to do it all again. So with that, I'm going to run into some of my insights about JP Court, hopefully for the benefit of people who haven't practiced there yet. I like to preface it by saying really most of my experience, almost all of it, has been with JPs in Travis County. And my experience with them all has been positive in respect to them as jurists. We're fortunate in that they're all attorneys, so they're all knowledgeable about the law. They all care about coming to the right outcome. So my experience has been very good. It may vary across Texas, but even in the best of circumstances, the purpose of this presentation is that, or it's rooted in the fact that even with a good quality judge, JP Court's just kind of a different animal than practicing in county court or district court. First of all, it's really not big at all on pretrial procedure. I speculate that a lot of that kind of stems from the fact that most cases that go to JP Court or small claims court can be resolved in like a hearing that's like at most an afternoon, frequently like an hour and a half. I mean, they see a lot of small claims, they see a lot of evictions, collection stuff, that sort of thing. And I mean, from a judge's perspective, if you can knock a case out on the merits in a couple hours, why bother with entertaining a motion for summary judgment? On the same token, discovery can be a problem. First of all, if you're actually operating under the small claims court within that docket, you're not permitted to do discovery unless the judge explicitly grants a motion permitting it. Now, if you're in JP Court for the time being, the rules of discovery as they apply in other courts still apply in JP Court. Like the first rule under that section of the Texas Rules of Civil Procedure says unless there's a contrary rule here, all the other rules apply, which means all the rules of discovery. Right now, the Supreme Court is considering rules, and I think it's to the point where it's almost predestined that they're going to adopt them, which, to simplify, more or less kind of folds that entire JP process, the entire JP litigation process, into the small claims court, with a few exceptions there's a separate procedure now, explicitly separate for evictions, and explicitly separate provision for collection if you're collecting on a promissory note. But for the most part, you're just kind of general civil litigation in JP Court. It's all being folded into small claims court, or it will be. Hearings, when you actually get to a hearing on the merits. Rules of evidence. Well, right now, if you look at Texas Rules of Evidence 101, it specifically says nothing in this document applies to small claims court. So rules of evidence don't apply. They do apply for the time being in proceedings in the JP court, but that's all within the discretion of the judge. My experience has been that JPs, I have not known a JP in Travis County that would not entertain an evidentiary objection. They'd listen to it and they'd consider it on its merits. Whether or not it's granted and whether or not it really makes a difference in the big scheme of things when you're in a bench trial situation is another question. I think the thing to do there is to operate under the assumption when you're putting together your case that probably everything is more or less going to get in one way or another, and accept that. Accept the bad parts of your case, include that in your preparation, and just do the best you can with what you got. And I'll get back to that in a second. But another thing just about the basic procedure, don't assume you're in the driver's seat. I mean, I've experienced the same thing in other courts. I mean, I've experienced this in jury trials in federal court. But particularly in JP court, frequently the judges take a very active role in developing the facts of their case. And I think it's not a bad thing, and I think it's probably the result of dealing with so many folks who are not attorneys. I mean, just in terms of time management, they need to take an active role in parsing the wheat from the chaff. But it can surprise you. I mean, for instance, I was in an eviction proceeding before JP, who will remain unnamed, and sat down with my client. I was in the defense position at this point. And he said, okay, stop me if any of you all disagree with this. And he started reading through this thing like, you had a lease, you breached the lease, you're going to pay this much. He was just proving up the case for the plaintiff. I was like, stop me if you disagree with any of this. Like, Judge, I do. But don't be surprised if that happens. You know, I think this kind of all boils down to, I think that they act rather pragmatically in the interest of the pursuit of justice. So one of the consequences of that is I think you're unlikely to win a case on a technicality. You know, I think it's probably going to go to the merits. It's probably going to be based on their sense of justice. But on the same token, I had an incident in another JP court where I showed up with a worker just to walk him through a default judgment process, because by the time I found the case, the defendant had already defaulted. And I put together all the paperwork, everything required by statute, the certificate of last known address, the non-military affidavit. We walked up to the bench to the judge, and as I was trying to hand him those statutorily required documents, he said, order granted, here you go, off with you. And so things can be fudged. Let's see. Given the pragmatic environment, everything that I do and that I would recommend that you do in JP, whether it's a procedural motion, should you have a hearing on one, or something to the merits, I always just focus on the fairness of it in every circumstance, because you're not going to win on the technicalities of black letter law. They want to come to a just result, which is good. And my advice there, this is not trial advocacy, and I'm not qualified to teach trial advocacy, but it would be to keep to the fairness of it, but not be over dramatic. There's a temptation to do that, not necessarily from one of y'all, perhaps someone who watches this video later. Just bear in mind that they hear stuff like this all the time, and they don't seem very patient about things that have the air of descending into just a squabble. So, I just stick with the basics. My client was doing very hard, draining work. Either they were up on a roof in the beating Texas sun, or they were doing some sort of dirty, thankless job with their hands for the promise of a very modest wage, which would be, a compliment that it doesn't warrant, a very modest wage, and then they weren't even paid that, or they're in a situation where the employer just blatantly understood that this wasn't minimum wage. So just a fairness argument, because I mean, they see cases like this all the time, but not necessarily one of that just caliber. I mean, just something just that palpably wrong. It's worthwhile to point out to them. Also something to consider, it's worthwhile to fight like hell over venue. Now, in the plaintiff's position, you have more flexibility with that, obviously, since you're filing. Now, the list of elements that go into venue, that's in Chapter 15 of the Civil Practice and Remedies Code, is shorter when you're dealing with justice court or small claims court. The best provision in there for you is that you can either file where the defendant lives. Well, no, that's not the best one. The best one is you can also file where they entered into the agreement that work was performed pursuant to. So if your defendant lives up in Williamson County and your guy's in Austin, and that's where they called him up to hire him, I would argue you have venue in Austin. Again, not to get too much into specifics, but I would do everything you possibly can to avoid practicing in Williamson County. And bear in mind that, assuming you don't have like a statute of limitations problem, which you probably won't, you can always non-suit without prejudice and refile on a better venue, assuming that you have the right to venue there. Something else to think about, be creative with your witnesses. It may be small claims court or it may be justice court, but you still have the option to present a creative expert witness if the circumstances warrant. I don't know what practice y'all are in, and sometimes we get lost in the whole Daubert analysis of publications and blah 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 with expert witnesses. But at its basic level, an expert witness can be a mechanic that you bring in who fixes cars every day to estimate how much it's going to cost to fix this car. I mean, same thing that people go to him or her for every day. They can testify about that. It's valid opinion testimony. I had a case with a guy who had undeniably performed a certain set of work, and the dispute was how much they had agreed to pay, per unit of time. And he said, well, I agreed to this, and the employer was like, no, you agreed to about half that. And I happened to meet a general contractor who, strangely enough, both worked in that area of construction and in that same basic geographic area. And I presented the facts to her, and she said, well, heck, the plaintiff, what he's saying, that hourly rate would be a deal. What the defendant is saying is just ridiculous. And so, that's valid testimony of custom and practice in that industry. And so just keep that in mind. People who are qualified and have experience in a particular area can often offer expert testimony that a judge will likely find probative, or a jury will. Which segues into whether or not you want a bench trial or a jury trial in one of these cases. Like I said, you can demand a jury as late as a day before the trial, for a cost of $5, assuming you haven't filed an affidavit of inability to pay, in which case it's free. My advice there would be is if you're dealing with a case that where credibility goes to an issue, or you have general damages, or just something that's not set out in writing, you're probably better off going with a jury, because just generally speaking, juries are more likely to give way to passion than a judge. And that can cut both ways, one way or the other. But on that basis, I think they're probably more likely to find liability, say, based on testimony about a verbal contract in the absence of a written contract. And they're more likely to just set a reasonable number on it rather than being worried about some of the minutia that a judge might get into sometimes. On the other hand, if you're dealing with a case where you really need to get the fact finder to focus on the minutia of something, like the explicit language of one paragraph in some sort of written agreement or ordinance or something like that, or if you're going to
There's a car alarm going off. It's a Honda Element, beige color.
That's fine. If you have a contract provision, or if the damages require that someone do math in order to calculate the result, I would go with a judge over the jury. But, you just have to kind of feel that out. And really, without Chris here, that's the end of my presentation. It is 12:30. Do any of you all have questions?
I had a JP case in Williamson County involving a undocumented contractor who was stiff. I ended up mediating it because I felt like they were going to arrest him and deport him if I took him up to the Williamson County Justice Center. He was going to have to drive up there, and I don't know. Do you have any thoughts about that? Or that's been a real problem. Getting justice. That bring any kind of. First of all, there's a lot of people that stiff people up there because of that.
Mm-hmm.
And then what am I supposed to do? Tell my client to walk in the lines then? You know what I mean? Where there's sheriffs and constables and law enforcement all over the place. He probably doesn't have a license. It's not worth the $4,000. You know what I mean? To basically risk his life and his family's life to. I don't know. Have you run into that situation? Do you have any thoughts on that?
I have, and I agree. You just have to bear in mind where there may well be circumstances where it's just too dangerous to pursue a claim like that. Now, you may be able to be creative, like non-suiting and filing in Travis County, or
I hadn't thought about that.
yeah, or if you can't get venue in justice court, maybe you can file in county court. If you're already involved in it, it's not a big step up to county court. perhaps you can try to take it to settlement without actually, going to trial, without actually having to introduce your client's testimony, so he doesn't actually have to go up there.
That was kind of my main thing. I was just like, I just do not want to take my guy and his witnesses into that area.
Or-
It's just too dangerous.
Or, there's always the opportunity to file with TWC or to, I don't know if it's worthwhile filing a wage theft claim with the DA up there.
That's a new one.
Yeah, it's true. But that's, yeah, I mean, I agree. There's situations where I wouldn't send a person into what I perceive to be the lion's den. In Travis County, I don't think that's an issue. I've never perceived any judge or law enforcement or any of the bailiffs in court or any person that I've encountered ever in my personal experience, I have yet to perceive one who cared about immigration status. They didn't consider it. They weren't going to pursue it. It wasn't really on their radar. That's been my experience in Travis County. In Williamson County, I would proceed with much trepidation.
Have you, what do you think about the JPs up there? Are they reasonable once you actually get there?
I haven't had much experience with them, to be honest. I know that most of them aren't attorneys, though I had one experience in front of one JP, and we were really just arguing about whether or not my client qualified for a free appeal to county court. And she was pretty good on that issue. But I mean, honestly, I can't speak to that very well. I would just ask around. In Williamson County, too, if you have a case up there and you think about appealing into county court, bear in mind they don't have any e-filing. It seems to be set up in a very hometowny kind of way, to the benefit of local attorneys. So I try not to go up there. Anything else? Yes.
Can you describe in a little more detail this kind of new concept of, I think you call it unbundled services?
Sure.
This low bono kind of work?
Sure, absolutely. It depends on the area of law. It's not something that'd be applicable to, an FLSA case like Edmund just talked to us about. But it's been explored pretty heavily in the area of, right now the thing being done like officially, the Texas Supreme Court level is the pro se divorce forms, where you're dealing with someone that doesn't have any property and they don't have any children, so it's a pretty straightforward procedure. I mean, just to use that as an example, it's an area of the law where a lot of the work is really heavily balanced on the front end in drafting the applicable motion and that sort of thing. But the actual appearance time in court is usually reasonably straightforward, and a lot of people can kind of get through it with like a script, for instance. And so I know, in one nonprofit here in town has a statewide program where they'll do that front end stuff for anyone anywhere in the state. And then that person goes and takes care of the hearing themselves, which makes sense in their perspective and also in the perspective of a private practitioner, because sitting and waiting in court is a huge amount of time, which would translate into a huge expense either for your client or for your nonprofit organization. And the benefit's very low. And so, I mean, basically what the calculus does is it looks at the type of cases and looks at what facets of the case will get you like the biggest bang for your buck, your most results for your investment of time. And so other areas where some things have been done with this, for instance, have been like landlord-tenant cases where, tenants have rights under Chapter 92 of the Property Code. And so if you go to the website for the Austin Tenants Council, for instance, you'll find draft pleadings for failure to return a security deposit. They'll give you an example letter that you have to send certified with instructions. You need to send this certified, and here's a petition you can file. That would be another example. If one of those people came to me for advice and I gave them advice, I'm like, this is how you can set up your evidence. This is what you need to do for service of process. Best of luck to you. That would be an example of an unbundled service.
And so you would just make clear in your representation agreements
Yes.
very explicitly what services you're providing and what not?
Yes, absolutely. The rules of professional responsibility explicitly permit for that sort of thing. So yeah, you just need to be explicit within your representation agreement that this is the limit of what I'm going to do. In fact, at TCRP, we routinely do that if when we're investigating claims. We sign a limited representation agreement just to make clear that, we haven't agreed to represent you yet. But yeah, so and there are models out there too. I think everyone has my email address. If you want one, I'd be happy to shoot one to you. So I think it's the way of the future, barring, the elimination of poverty. Anyone else have a question? Well, in that case, I think we're going to wrap up with a couple words from Patty here to bid you goodbye. And for my part, I really appreciate everyone coming out.
Thanks, Brian. Well, I want to thank everyone for being here today, especially the people that made this event happen, Brian McGivern, Virginia Raymond, as well as Chris Kaiser. This wouldn't have been able to happen without them. It takes a lot of work to organize events like this. And also our presenters that came, Eva and David and Edmund and Brian, all of the knowledge and experience that they've shared with us are very, very valuable. I hope everyone is taking away a lot from this today. You've learned about how to be a really good, responsible attorney and take into certain considerations in working with low-income workers, the importance of bringing together both organizing struggles together with legal action to be most effective to empower workers, the ins and outs of the Fair Labor Standards Act, as well as how to be effective in JP court. So I just want to remind y'all that the fight continues. Workers will always fight for their rights and to have fair and dignified working conditions. It's something so basic, but something that so many people are denied. And you all as attorneys have a particular role to play in helping workers to have access to that right. And there are lots of different opportunities. You can fill out the sheet that I gave to you and turn it into me at the end. Also, there's a part in our organization that focuses a lot on policy to pass laws to protect workers. In this state, workers don't have a right to a rest break. They don't have a right to receive medical compensation when they get hurt on a job. There's a lot of things that workers are denied, and so we feel it's important to make demands to our policymakers to ensure that workers in Texas stop dying on the job. Every 2.5 days, a construction worker dies in the workplace, and Texas is the most deadly industry. Construction is the most deadly industry across the country. So I want to invite y'all to our national or statewide day of action called the Day of the Fallen. People will be coming from all across the state, and we will be marching down Congress Avenue, presenting our new policy initiatives for 2013, and asking our state legislators to pass laws to ensure that workers come home at the end of the day, that they have a fair pay, that they can get drink water and take a rest after working out in the hot sun. So I'm going to pass around these invitations. It's February 27th at 4 p.m. It's a Wednesday. We'll be meeting at the Federal Building and marching down Congress and ending with a press conference in front of the Capitol. So I hope you all can make it out. And that's all I have to say. Thank you all so much for coming today. Appreciate it.